Je me nomme Safika Doukourosi, je suis étudiante à l'université de Goma en première année de master. Je suis ici à Kigali avec mon coéquipier qui se nomme Chipamba Ntikala Josué. Il est aussi étudiant à l'université de Goma en deuxième année de master droit public interne. Nous sommes accompagnés de notre coach qui se nomme Franck Choukuru. Il est assistant à la faculté de droit de l'université de Goma. Je suis heureuse et reconnaissante. Je ne m'attendais pas à revenir avec le prix de la meilleure plaideuse. D'ailleurs, je pensais qu'on ne donnait que le prix du meilleur plaideur et je pensais que c'était tous les sexes confondus. Je l'ai appris sur place et j'étais très contente. Alors, remporter le prix de la deuxième place, c'est aussi une très grande expérience parce qu'avec mon coéquipier, nous avons beaucoup appris de cette édition. Et nous pensons pouvoir aider ceux qui viennent après nous, de l'université ou d'ailleurs, à pouvoir prendre à cœur ce défi qui est nôtre, ce défi de pouvoir faire respecter le droit international humanitaire, que ce soit en temps de paix comme en temps de guerre surtout, et aussi de respecter le droit de l'environnement et toutes ces notions qu'on nous a apprises ici tout au long des formations. Sincèrement, je n'ai pas eu le cours de droit international humanitaire. J'ai eu par contre le cours de droit international public. C'est sûrement le seul cours à caractère international que j'ai eu. Et le droit international des investissements aussi. Mais pour le reste, vu que je sais qu'il y a d'autres étudiants qui sont sûrement dans la même situation que moi et qui s'intéressent au droit international humanitaire mais n'ont pas eu à choisir cette option-là, je pense qu'il serait important de pouvoir organiser plus fréquemment des séminaires en droit international humanitaire, en droit international de droits de l'homme et des séminaires qui seront ouverts à tout le monde pour essayer de faire comprendre aux gens ce qu'est le droit international humanitaire. Une fois, dans les séances des formations qu'on nous donnait, l'un des experts avait dit qu'il conseillait aux gens de pouvoir être des conseillers juridiques des groupes armés. Je pense que je soutiens son avis. Parce que si les rebelles prenaient conscience de ce qu'est le droit international humanitaire, je crois qu'ils agiraient un peu mieux avec la vie humaine et tout ce qui pourrait nuire à l'humanité.
My name is Mukisa Joshua William and I'm from Makerere University in Uganda. For this round of the Great Lakes Moot Court competition, my partner was Mirungi Prima Elizabeth. Well, I expected this to be mainly a moot competition, but when I did arrive, I noticed that besides it being a moot competition, there was an opportunity to learn. We had conferences, trainings, we had interactions, the opportunity to network with people from diverse backgrounds, and this was a cherry on top because just the order of the competition alone was enough for you to acquire intellect, knowledge, an understanding of this tricky subject, but then with the opportunity to interact with these experts who were there, free access between the students and professors, persons with PhDs, authors, indescribable would be the best word. But also, I think that it inspires students, the young generation. It gives them an opportunity, a space where they can interact with their mentors, people that they would otherwise only meet in books. And so I find that the expectation of it just being a competition has been far surpassed, with this being an opportunity to make new friends, interact with your inspiration, mentors, and also discover new path in life. Absolutely. the knowledge acquired here can be utilized, to arbitrate some of these armed conflicts taking place around the African continent, in the Great Lakes region, how to champion dialogue, interact with people, promote methods of transitional justice, but also bring some of the top criminals to responsibility. And I find that it is a practical activity or engagement that we had here. Not only am I having the opportunity to do what a lawyer would only have the chance at the highest level of a national court, that is at the Supreme Court or at the International Criminal Court. Here, I'm doing that, going 20 or 30 years into the future and practicing, exercising my ability to persuade the court, to exercise interpretation on complex matters of law. And I know that the knowledge acquired here will be utilized in my work throughout, the African continent, establishing the legal footprint in my region and the various areas within the Great Lakes territory. And I'm also looking at interacting with fellow youth students, guiding them, offering them some advice, what path to pursue, and how best they can also become players in dealing with these issues that really affect us a lot on the continent. Definitely, this activity can help people get access to justice because, one, it is equipping the lawyers that are going to represent these people. But two, it is also creating awareness for these judicial mechanisms, because many people would think that when crimes against humanity are committed, or when war crimes are committed, or things like genocide, they're all left to the government to decide what should be done. But then you get to realize that individuals too can participate. The lawyers can press charges through organized groups like NGOs. They can come together and educate people, educate governments, educate leaders about the law of armed conflict. And this then sets a standard through which people know how best they can defend themselves and the obligations that any people engaged in armed conflict would have for civilians and protected persons. So I definitely see this as something that is relevant and is going to enable people get access to justice, because here they do know now that there are crimes like genocide. It is a crime, it is an international crime. So it sheds light on the avenues available for one who is seeking justice.
Je m'appelle Reine Mahoro, je viens de l'Université Lumière de Bujumbura en 3e année baccalauréat dans la faculté de droit. Et je suis ici à Kigali avec mon coéquipier qui s'appelle Steph Darcy Iradukonda et notre coach qui s'appelle Deo Naongiriye. Alors, il est très important de parler du droit international humanitaire dans notre région des Grands Lacs parce que c'est un droit qui va de pair avec les conflits armés qui sont dans certains de nos pays. Alors, pour le cas pratique qu'on a eu à traiter, c'était vraiment un cas complexe parce qu'on devait analyser la situation en profondeur pour pouvoir déterminer les crimes qui étaient en train d'être commis dans ce pays qui était un pays fictif, mais qui pourrait effectivement être un pays de l'Afrique ou bien d'un autre continent. Et avoir à traiter ce cas nous orientait en tant que juristes sur des crimes effectivement du droit international humanitaire, mais aussi les droits humains.
My name is Joseph Isaac Masangula, a student from the University of Dar es Salaam in Tanzania. My team coach is Dr. Petro Protas, and my teammate is Gertrude Makunganya. My expectations when I was chosen to participate in the Great Lakes training in international humanitarian law and human rights were actually going to a platform where I can learn a lot of stuff, because In the Great Lakes, we have countries which are facing several problems. I can take an example of DR Congo and Burundi, where several problems are occurring every day. So my expectations were, I'm going to a platform where I will meet vibrant lawyers of tomorrow who are going to discuss solutions on how can we make efforts to ensure no any problem persists within the Great Lakes region. The message I'm going to go back with in my country, Tanzania, is Africa is one. And we Africans must ensure we unite. We unite in a manner, we need to ensure peace and stability within the Great Lakes region. Not only because Tanzania has an everlasting peace, then I should just sit and relax. No. As a youth, I have the responsibility to ensure I take a full command in order to ensure there is an everlasting peace, not only in my country, but also in the whole region of the Great Lakes.
My name is Jen Namai Wafula and I am from Kenyatta University. It's in Kenya. My teammate is Joel Ngugi Kabena and our coach is Jean Keraka Nyaboke. The quality of the topics discussed was a good one. There was a good choice on the topics. Indeed, I got to learn that the environment is one of the targets by the belligerents. So it's been a good choice of topics by the organizers, and I wish that they continue doing more of that, that they continue with that pace so that we get to really understand from the in-depth what this topic of law entails. Let us not leave any topic, no matter how little time we have, let us get to exhaust at least everything that might be a target of the belligerents in war. The knowledge acquired from this training is really going to be beneficial to me, to my peers, and to my community. First, to me, because next semester I'm going to undertake a unit on international law. To me, to my peers, and to my community. First, to me, because next semester I'm going to undertake a unit on international humanitarian law. It is an optional unit, but I have opted to do it because I want to get to understand more what law is and the rules that govern war. To my peers, I will get to tell them about iPeace and what iPeace is doing in relation to international humanitarian law. They will get to understand from a different perspective, indeed, that there is an organization that educates persons about this topic of law. And to my community, really, when I get out there and share knowledge that I have acquired from this training, the public out there, law students, non-law students, they will get to understand the laws that govern war, and they will get to know that indeed, even if we are taking part in this armed conflict, there are rules that we must adhere to, and that will make a change to the way people conduct themselves during armed conflict. The experience I had from this training, it actually started from the memorials writing to the advisory panel and to the pleadings session. It's been a learning experience. You get to be corrected by judges, you get to be corrected by the panelists, you get a chance to ask questions from the expert during the conference and also at a personal level. So for me, it has been a learning experience and one I will always be proud of. And as at now, I can say I am living my dream, getting to one of the cities that I have always wanted to be in. So I am thankful to iPeace for this opportunity to experience something I have always wanted to experience. Yeah.
Je me nomme Anchiza Migani Ryan. Je viens de l'Université catholique de Bukavu. Je constituais une équipe avec mademoiselle Kaambuta Sidebora. Oui, notre université, notre équipe a dû remporter le prix de la meilleure équipe dans ce concours personnel à l'équipe, mais une victoire qui appartient à tous. En réalité, le programme à lui seul porte déjà une formation et le concours n'a consisté que dans l'application de ce qui a été appris. Or, tous nous avions appris, certaines circonstances se sont déroulées, mais en réalité, dans ce type de compétition, dans ce type de programme, dans ce type de formation, soit on est gagnant, soit on est gagnant. Certainement, notre tâche à nous, en ayant participé à ce programme, notre tâche à nous, en ayant apprécié le programme, bien sûr aussi peut-être en ayant gagné ce concours, c'est de pouvoir relayer cette information à toutes les autres personnes. Non seulement le relais des matières qui ont été apprises autant que nous le pourrons, mais aussi le relais du programme tel qu'organisé par iPeace. Et c'est ainsi que dans notre université par exemple, un club déjà dans ce sens a déjà été institué durant cette année, un club des droits humains. Pourquoi ne pas mettre aussi un club de droit international humanitaire et qui s'occupera particulièrement non seulement de la formation des étudiants autour de cette thématique qui est très importante, mais aussi de pouvoir faire participer les étudiants à de tels ateliers, car comme on dit, dans de types de clubs, l'on peut étudier de la théorie, mais dans ce type de programme, on apprend beaucoup plus par la pratique.
Je me nomme Safika Doukourozi, je suis étudiante à l'université de Goma en première année de master. Je suis ici à Kigali avec mon coéquipier qui se nomme Chipamba Ntikala Josué. Il est aussi étudiant à l'université de Goma en deuxième année de master droit public interne. Nous sommes accompagnés de notre coach qui se nomme Franck Choukuru. Il est assistant à la faculté de droit de l'université de Goma. Je suis heureuse et reconnaissante. Je ne m'attendais pas à revenir avec le prix de la meilleure plaideuse. D'ailleurs, je pensais qu'on ne donnait que le prix du meilleur plaideur et je pensais que c'était tous les sexes confondus. Je l'ai appris sur place et j'étais très contente. Alors, remporter le prix de la deuxième place, c'est aussi une très grande expérience parce qu'avec mon coéquipier, nous avons beaucoup appris de cette édition. Et nous pensons pouvoir aider ceux qui viennent après nous, de l'université ou d'ailleurs, à pouvoir prendre à cœur ce défi qui est nôtre, ce défi de pouvoir faire respecter le droit international humanitaire, que ce soit en temps de paix comme en temps de guerre surtout, et aussi de respecter le droit de l'environnement et toutes ces notions qu'on nous a apprises ici tout au long des formations. Sincèrement, je n'ai pas le cours de droit international humanitaire. J'ai eu par contre le cours de droit international public. C'est sûrement le seul cours à caractère international que j'ai eu. Et le droit international des investissements aussi. Mais pour le reste, vu que je sais qu'il y a d'autres étudiants qui sont sûrement dans la même situation que moi et qui s'intéressent au droit international humanitaire mais n'ont pas eu à choisir cette option-là, je pense qu'il serait important de pouvoir organiser plus fréquemment des séminaires en droit international humanitaire, en droit international de droits de l'homme, et des séminaires qui seront ouverts à tout le monde pour essayer de faire comprendre aux gens ce qu'est le droit international humanitaire. Une fois, dans les séances des formations qu'on nous donnait, l'un des experts avait dit qu'il conseillait aux gens de pouvoir être des conseillers juridiques des groupes armés. Je pense que je soutiens son avis. Parce que si les rebelles prenaient conscience de ce qu'est le droit international humanitaire, je crois qu'ils agiraient un peu mieux avec la vie humaine et tout ce qui pourrait nuire à l'humanité.
My name is Mukisa Joshua William and I'm from Makerere University in Uganda. For this round of the Great Lakes Moot Court competition, my partner was Mirungi Prima Elizabeth. Well, I expected this to be mainly a moot competition, but when I did arrive, I noticed that besides it being a moot competition, there was an opportunity to learn. We had conferences, trainings, we had interactions, the opportunity to network with people from diverse backgrounds, and this was a cherry on top, because just the order of the competition alone was enough for you to acquire intellect, knowledge, an understanding of this tricky subject, but then with the opportunity to interact with these experts who were there, free access between the students and professors, persons with PhDs, authors, indescribable would be the best word. But also, I think that it inspires students, it gives them an opportunity, a space where they can interact with their mentors, people that they would otherwise only meet in books. And so I find that the expectation of it just being a competition has been far surpassed, with this being an opportunity to make new friends, interact with your inspiration, mentors, and also discover new path in life. Absolutely. The knowledge acquired here can be utilized, to arbitrate some of these armed conflicts taking place around the African continent, in the Great Lakes region, how to champion dialogue, interact with people, promote methods of transitional justice, but also bring some of the top criminals to responsibility. And I find that it is a practical activity or engagement that we had here. Not only am I having the opportunity to do what a lawyer would only have the chance at the highest level of a national court, that is at the Supreme Court or at the International Criminal Court. Here, I'm doing that, going 20 or 30 years into the future and practicing, exercising my ability to persuade the court, to exercise interpretation on complex matters of law. And I know that the knowledge acquired here will be utilized in my work throughout, the African continent, establishing the legal footprint in my region and the various areas within the Great Lakes territory. And I'm also looking at interacting with fellow youth, students, guiding them, offering them some advice, what path to pursue, and how best they can also become players in dealing with these issues that really affect us a lot on the continent. Definitely, this activity can help people get access to justice, because one, it is equipping the lawyers that are going to represent these people, but two, it is also creating awareness for these judicial mechanisms, because many people think that when crimes against humanity are committed, or when war crimes are committed, or things like genocide, they're all left to the government to decide what should be done. But then you get to realize that individuals too can participate. The lawyers can press charges through organized groups like NGOs. They can come together and educate people, educate governments, educate leaders about the law of armed conflict. And this then sets a standard through which people know how best they can defend themselves and the obligations that any people engaged in armed conflict would have for civilians and protected persons. So I definitely see this as something that is relevant and is going to enable people get access to justice, because here they do know now that there are crimes like genocide. It is a crime, it is an international crime. So it sheds light on the avenues available for one who is seeking justice.
Je m'appelle Reine Mahoro, je viens de l'Université Lumière de Bujumbura en 3e année baccalauréat dans la faculté de droit. Et je suis ici à Kigali avec mon coéquipier qui s'appelle Steph Darcy Iradukonda et notre coach qui s'appelle Deo Naonghiriye. Alors, il est très important de parler du droit international humanitaire dans notre région des Grands Lacs parce que c'est un droit qui va de pair avec les conflits armés qui sont dans certains de nos pays. Alors, pour le cas pratique qu'on a eu à traiter, c'était vraiment un cas complexe parce qu'on devait analyser la situation en profondeur pour pouvoir déterminer les crimes qui étaient en train d'être commis dans ce pays qui était un pays fictif, mais qui pourrait effectivement être un pays de l'Afrique ou bien d'un autre continent. Et avoir à traiter ce cas nous orientait en tant que juristes sur des crimes effectivement du droit international humanitaire, mais aussi les droits humains.
My name is Joseph Isaac Masangula, a student from the University of Dar es Salaam in Tanzania. My team coach is Dr. Petro Protas, and my teammate is Gertrude Makunganya. My expectations when I was chosen to participate in the Great Lakes training in international humanitarian law and human rights were actually going to a platform where I can learn a lot of stuff. Because in the Great Lakes, we have countries which are facing several problems. I can take an example of DR Congo and Burundi, where several problems are occurring every day. So my expectations were, I'm going to a platform where I meet vibrant lawyers of tomorrow who are going to discuss solutions on how can we make efforts to ensure not any problem persists within the Great Lakes region. The message I'm going to go back with in my country, Tanzania, is Africa is one. And we Africans must ensure we unite. We unite in a manner, we need to ensure peace and stability within the Great Lakes region. Not only because Tanzania has an everlasting peace, then I should just sit and relax. No. As a youth, I have the responsibility to ensure I take a full command in order to ensure there is an everlasting peace, not only in my country, but also in the whole region of the Great Lakes.
My name is Jen Namai Wafula and I am from Kenyatta University. It's in Kenya. My teammate is Joel Ngugi Kabena and our coach is Jean Kerakanyaboke. The quality of the topics discussed was a good one. There was a good choice on the topics. Indeed, I got to learn that the environment is one of the targets by the belligerents. So it's been a good choice of topics by the organizers, and I wish that they continue doing more of that they continue with that pace so that we get to really understand from the in-depth what this topic of law entails. Let us not leave any topic, no matter how little time we have, let us get to exhaust at least everything that might be a target of the belligerents in war. The knowledge acquired from this training is really going to be beneficial to me, to my peers, and to my community. First, to me, because next semester I'm going to undertake a unit on international humanitarian law. It is an optional unit, but I have opted to do it because I want to get to understand more what law is and the rules that govern war. To my peers, I will get to tell them about iPeace and what iPeace is doing in relation to international humanitarian law. They will get to understand from a different perspective, indeed, that there is an organization that educates persons about this topic of law. And to my community, really, when I get out there and share knowledge that I have acquired from this training, the public out there, law students, non-law students, they will get to understand the laws that govern war, and they will get to know that indeed, even if we are taking part in this armed conflict, there are rules that we must adhere to, and that will make a change to the way people conduct themselves during armed conflict. The experience I had from this training, it actually started from the memorials writing to the advisory panel and to the pleading session. It's been a learning experience. You get to be corrected by judges, you get to be corrected by the panelists, you get a chance to ask questions from the expert.
Oui, notre université, notre équipe a dû remporter le prix de la meilleure équipe dans ce concours. Mais en soi, il ne s'agit pas simplement d'une victoire qui est personnelle à l'équipe, mais une victoire qui appartient à tous. En réalité, le programme à lui seul porte déjà une formation et le concours n'a consisté que dans l'application de ce qui a été appris. Or, tous nous avions appris, certaines circonstances se sont déroulées, mais en réalité, dans ce type de compétition, dans ce type de programme, dans ce type de formation, soit on est gagnant, soit on est gagnant. Certainement, notre tâche à nous, en ayant participé à ce programme, notre tâche à nous, en ayant apprécié le programme, bien sûr aussi peut-être en ayant gagné ce concours, c'est de pouvoir relayer cette information à toutes les autres personnes. Non seulement le relais des matières qui ont été apprises autant que nous le pourrons, mais aussi le relais du programme tel que organisé par iPeace. Et c'est ainsi que, dans notre université par exemple, un club déjà dans ce sens a déjà été institué durant cette année, un club des droits humains. Pourquoi ne pas mettre aussi un club de droit international humanitaire et qui s'occupera particulièrement non seulement de la formation des étudiants autour de cette thématique qui est très importante, mais aussi de pouvoir faire participer les étudiants à de tels ateliers, car comme on dit, dans de types de clubs, l'on peut étudier de la théorie, mais dans ce type de programme, on apprend beaucoup plus par la pratique.
Je me nomme Safika Doukourozi, je suis étudiante à l'université de Goma en première année de master. Je suis ici à Kigali avec mon coéquipier qui se nomme Chipamba Ntikala Josué. Il est aussi étudiant à l'université de Goma en deuxième année de master de droit public interne. Nous sommes
Thank you very much, Bailiff. Good morning, everyone. Welcome to this court. I am Justice John Joseph Wamara presiding. Let me have this privilege to welcome members of the bench, and they will each introduce themselves.
Irene Thomas.
I'm Emily.
I'm Bai Nelson.
Yes, and I'm Chira Brian Alex.
Lia Mahari Radai.
I'm Innocent Msonera.
Very well. We want to welcome you all to this chamber. I want to ask that I have Justice Kategera Irene to give us a few rules of this court. Thank you.
Thank you, Mr. President. Good morning, ladies and gentlemen. I am going to give a few instructions regarding this session. Number one, regarding time, we have 1 hour. Each side will have 25 minutes for submissions, and then 5 minutes for rebuttals and 5 minutes for rebuttals. During the session, once the bench poses a question, we have advised the bailiff to stop the time and resume it once the party is giving answers. There is going to be introduction for the councils. I only see name tags for one side. I would recommend that the other side write them down, pass it to bailiff so that they can come to the bench. We would also advise the councils to allocate the time that you're going to use to deliver your submissions. And may we emphasize that the time you allocate to each other is as equal as possible, because the bench will determine the scores of the team based on individual performance. I think that's all.
Thank you very much, Justice Irene. Let me give this opportunity to members of the councils before us to introduce themselves. Please. Let's start with the applicants. Just the introduction, yes. Oh, okay. 1 minute.
Presiding Judge, Honorable Judges, may it please this Honorable Court, good morning. I am Lomola Jonathan, appearing as first counsel for the prosecution, and I'm joined today by my co-counsel, Ms. Alan Dulu, appearing as second counsel for the prosecution.
Very well. The code, please.
Pardon?
Team code?
Ellingwood, ELLINGWOOD.
Very well. Defendants, respondents. Prosecution.
Thank you so much, Presiding Judge and members of the Honorable Bench. My name is Kamara Castro, together with my co-counsel, Christine Miruka, representing Team Eckington.
Eckington?
Yes.
Your name, please?
Kamara Castro.
Castro and?
Christine Miruka. Yes.
Thank you very much. With the introductions gone, if the bench is ready, could you just kindly write those names and pass that to the bench, please? Okay. The names of the, please. Thank you. And Eckington. Very well then, I think, with the bench ready? Bench ready? Very well, applicants, take to the stand. Thank you.
Presiding Judges, Honorable Judges, may it please this Honorable Court, good morning. It is an honor to appear before this court representing the Attorney General of the Federal State of Balmoral. As earlier introduced, I am Lomola Jonathan, appearing as first. I shall take the first 13 minutes to address the contextual elements the prosecution has charged Commander Helmer with. These are war crimes under Article 82B1, Article 82B2, and Article 82B4 of the Rome Statute. I shall also address Commander Helmer's command responsibility in regards to these war crimes. With me is my colleague and co-counsel, Ms. Alan Dulu. She shall take the next 12 minutes to submit on the objective and subjective elements of these war crimes. We respectfully reserve 5 minutes for rebuttals. With the leave of this court, the prosecution would like to begin its substantive submissions. Odious, atrocious, and abhorrent. Your Honors, these words hardly do justice to describe Mr. Helmer's heinous violations of fundamental laws of war, laws upheld by belligerents since time immemorial. In its pursuit for justice, the prosecution shall demonstrate beyond reasonable doubt that Commander Helmer did commit the war crimes he has been charged with. I shall begin with the contextual elements of these war crimes, where the prosecution submits that the contextual elements have been met for three key reasons. First, that the conflict in Tivania started off as a non-international armed conflict, hereinafter referred to as a NIAC. Second, that this particular NIAC internationalized into an international armed conflict, hereinafter referred to as an IAC. And third, that the nexus and awareness requirements of these contextual elements have been met. I shall begin with the first limb, where the prosecution submits that the conflict in Tivania started as a NIAC by virtue of the fact that there existed a protracted armed violence between the government armed forces and an organized armed group which met the requisite level of intensity, and the armed group, which is IALIS, was sufficiently organized to constitute an armed group. Your Honors, this is in line with the 2025 decision by the ICC in Prosecutor versus Ekatom and Gaisona, particularly paragraph 3766, that set out the requirements needed for a NIAC to exist. The intensity requirement is met by virtue of the frequency of attacks and armed clashes done by IALIS and the government forces, which started in 2015, persisted in 2016, continued all the way to 2018, and ended in 2022.
Before then, there was no definition of NIAC under international humanitarian law or international criminal law.
Your Excellency, there were other definitions of NIAC, and this can be seen in the Prosecutor versus Ongwen ICC decision in 2021, and even the 2009 ICC decision in Prosecutor versus Lubanga, and it goes all the way back to the ICTY in the Prosecutor versus Tadic appeals judgment issued in 1999. Pardon? There's no treaty definition of a NIAC. Yes. Your Excellency, we also submit that IALIS is sufficiently organized to constitute an armed group for three reasons. That is, its military capacity, its logistical capacity, and its command structure. Its logistical capacity is quite evident by the sophisticated recruitment and training system that IALIS has. Its military capacity is also evident by the power that IALIS has to conduct coordinated attacks, and this can be seen in paragraph 25 and 26 of the record and paragraph 31 of the record, where it carried out coordinated attacks against civilian objects and NGO databases. With this, Your Excellencies, we submit that a NIAC does exist. On to the second limb of the contextual elements, we submit that this particular NIAC internationalized into an international armed conflict because the overall control test has been met. Your Excellencies, in 1999, the ICTY in the Prosecutor versus Tadic appeals judgment, specifically paragraph 145, stated that a NIAC can internationalize into an IAC where a foreign state indirectly participates in it. And in determining whether the foreign state indirectly participates in it through an armed group, the court set out the overall control test that ought to be met. The test provides for two things. First, that the foreign state has to be involved in planning and coordinating military actions of the armed group. And second, that the foreign state has to be involved in financing and giving logistical support to the armed group. Your Excellencies, both of these parts have been met. I shall begin with financing and provision of logistical support. And as evidence in paragraph 23 of the record, the Republic of Ksenia has been financing and providing logistical support to IALIS by virtue of the fact that it has given IALIS cars, uniforms, tactical equipment, and even trained members of the IALIS armed group. Moving on to the second requirement of planning and coordinating military actions of IALIS, we submit that this requirement has also been met. Your Excellencies, as evidence in paragraph 23 of the record, it is shown that there is a Ksenian military official within the ranks of EALIS. And it's upon this basis that we submit this particular requirement of planning and coordinating military actions of EALIS has been met. And let me draw paragraph 23.
Mere presence of a member of armed forces of Cassania should be enough to internationalize the conflict. Is that what you're saying?
Your Excellency, the Cassanian military official within the ranks of EALIS is a recognized member of the Cassanian military. And may I draw parallels between the case at hand and the Niletilic and Martinovic ICTY decision in 2003. In the Niletilic and Martinovic trial judgment, Your Excellencies, the court grappled with the same question of whether a foreign power was involved in controlling an armed group. And in finding that the Republic of Croatia was involved.
Mere presence is enough to...
Yes, Your Excellency, and I want to draw parallels between the Niletilic decision and this particular case. Your Excellencies, in the Niletilic decision, the Republic of Croatia, Your Excellencies, had members of its own army within the ranks of the CVO, that is the Croatian Defense Council. And in addition to this, Your Excellencies, the court also found that Croatia was planning and organizing and coordinating military actions of the CVO by virtue of another fact, which is the CVO, which is the Croatian Defense Council, and the Croatian Army were working towards one same goal. That is the integration of the Bosnia and Herzegovina into Croatia from the greater Croatian community. Your Excellencies, these facts are strikingly similar to what we have at hand. And as can be evidenced in paragraph 23 of the record, and was seen in the Croatian case, Your Excellencies, there is the presence of an army official from the Cassanian army in the ranks of EALIS. And in addition to this, Your Excellencies, the president clearly comes out and shows that EALIS and Cassania are pursuing the same goal. That is the unity of the Ovak people within one state, which is strikingly similar to what the president of Croatia was seeking in the Niletilic and Martinovic decision. With this, we submit that this particular NIAC internationalized into an IAC. And on to the last requirement, Your Excellencies, we submit that the nexus and awareness requirement have been met by virtue of the fact that the war crimes Mr. Helmer has been charged with.
There are two tests under international law, overall control test and effective control test. Could you just address yourself to which one should be present to change the nature of the conflict?
In this particular case, Your Excellency, the overall control test is the right test. And as was discussed in the prosecutor versus Tadic appeals judgment, specifically paragraph 999 to 145, the court discarded the effective control test because it sets such a high bar that states will use to avoid responsibility for running proxy wars. Your Excellencies, back to our submissions, we submit that the nexus and awareness requirement have been met because these particular war crimes were committed by Commander Helmer in pursuit of a larger military goal, which was the quashing of EALIS, and he was aware by virtue of his fact as commander in charge of Operation Soma that there was an armed conflict. With no further questions on the contextual elements, I shall proceed to command responsibility. The prosecution asserts
have not committed or have they been committed? Will you or your colleague speak on the specific crimes that you're charging?
Your Excellency, we submit that the crimes have been committed, and I was demonstrating that the contextual elements of these three war crimes have been satisfied.
You're about to head into command
responsibility.
But do we not need to know about that the crimes have been committed before you go on to command responsibility?
Yes, Your Excellency. My co-counsel will ably demonstrate that the objective and subjective elements of these war crimes have been committed.
Proceed.
Proceeding with command responsibility, we submit that Commander Helmer is responsible under Article 28A of the Rome Statute for the atrocities committed by his troops for three key reasons. First, Commander Helmer had effective control and command over his troops. Second, Commander Helmer knew that his troops were committing these war crimes. And third, Commander Helmer failed to take necessary and reasonable measures to investigate and prosecute these war crimes. Your Excellency, on the first limb of this argument, we submit that Commander Helmer had effective control and command over his troops, and this is evidenced by the fact that he gave them direct orders to go commit war crimes. He had the power to send them to various locations, Your Excellencies.
Are you saying there was a given order to go commit crimes?
Yeah, war crimes.
You sure?
Crimes, yes.
Could you just direct us to that place where he gave direct orders for them to go and commit crimes?
Your Excellency, may I guide you to paragraph 45 of the record, where it is clearly stated that Commander Helmer directed his troops, directed his zonal commander to go to the city of Solvia and storm schools, radio stations, and hospitals.
Direct order from him?
Yeah, direct orders from him.
Very well.
Yes. This, Your Excellency.
I just want to find out, maybe you help me with this word. Was it explicit or implicit?
Your Excellency, it was direct orders, explicit direct orders from Commander Helmers. His troops were acting under his instructions.
Very well.
These, Your Excellencies, demonstrate that Commander Helmer had effective control and command over his troops. On to the second limb of command responsibility, we submit that Commander Helmer knew his troops were committing war crimes. Your Excellencies, as was stated in the 2016 ICC decision in the Prosecutor versus Bemba trial judgment, for one to be considered to have known that his troops were committing war crimes, he ought to have, one of the factors that is taken into consideration is the fact that he ordered his troops to commit those war crimes and his capacity within the ranks of the army. In this particular case, as demonstrated in paragraph 45, Commander Helmer did order his troops commit these war crimes. And by virtue of his position as the commander in charge of Operation Tisoma, he knew that his troops were using drones to cause terror, which is indeed a war crime.
Since we're only discussing command responsibility with you, and I'm guessing your council will talk about the war crimes, you're talking about the crimes allegedly committed that were stated under paragraph 25.
No, Your Excellency, 45.
45.
Yeah, yeah. This, Your Excellency, demonstrates that Commander...
Maybe let me just follow that question up a little bit. I noticed that as per the scenario that we have, at some point, the atrocities that are committed by PMLT, we know that there's been a partner in the Colonel's forces and PMLT. How would you categorize this as you talk about command responsibility? Would this still fall within scope?
Your Excellency, the PMLT forces are not under Commander Helmer's direct orders, or rather, PMLT is not under Commander Helmer. Commander Helmer was controlling or was in charge of the government forces in this particular case. The PMLT was a distinct armed group. Yeah.
So what's the import of the partnership?
Of the partnership. The war crimes you're charging Commander Helmer with are war crimes that his troops committed, not war crimes that the PMLT committed.
Very well, continue.
Your Excellency, by virtue of this, we submit that Helmer knew that his troops were committing war crimes. And on to the last limb of the command responsibility, we submit that Helmer failed to take necessary and reasonable measures to investigate and prosecute these war crimes. And this is clearly evident even to blind Bartimaeus, as was seen in paragraph 47 of the record, where Helmer received a report from iPeace telling him of the war crimes his troops committed. Yet instead of investigating them and prosecuting them, blind Bartimaeus, but instead of investigating them and prosecuting them, Your Excellencies, he commended them and likened their actions to patriotic and brave actions and terming them legitimate reprisals. It is pertinent that we remind this chamber that legitimate reprisals are prohibited under international humanitarian law, particularly Article 51(6) of Additional Protocol 1. Your Excellencies, I ask you today, what part of intentionally directing attacks against civilians and civilian objects is patriotic bravery? With this, I now cede the floor to my co-counsel to proceed with the submissions.
Just before that,
would you please try to guide the bench on your remarks regarding how exactly, or rather any particular procedures that you would suggest or advise drugs to investigate these atrocities that were done by his command?
should he have gone about it?
Yes, Your Excellencies. Commander Drax, Selma.
Just hold on. And the second aspect, could you please address yourself with regard to the peace agreement and amnesty law that provides drugs with immunity?
I shall begin. Okay. Yes.
Council, I also have a brief question for clarification. It's about this mode of liability the superior responsibility. From the case scenario, the facts, as you stated, point to the fact that the defendant allegedly issued direct orders to go and storm. That is not a direct order, a specific order to go and commit crimes. It's just storming an infrastructure that is, we all agree, belongs to civilians, but then going and attacking and storming does not equate to, say, go and commit crimes. So can you point to any other circumstantial or otherwise evidence that specifically says, pins the defendant that he actually wanted his subordinates to go and commit crimes? And then, tied to that is the fact that the effective control, the first component of the superior responsibility doctrine, requires the material ability to actually be able to reign on your subordinates. Do we have anything from the case scenario that shows that the defendant had that material capacity to actually effectively control the subordinates?
I think you take as little time as you can to answer the questions, then you can give.
I shall begin with the question on the amnesty, Your Excellencies. And as you can be seen in Article 27(2), amnesties do not grant anyone immunity against prosecution for crimes that have been committed within the jurisdiction of this particular court. Moving on to investigation, Your Excellencies, it is pertinent to note that Commander Helmer had various zonal commanders who he could order to investigate whether these particular war crimes had taken place, and if they did take place, the responsible people could be court-martialed and actions taken against them, Your Excellency. And on to Your Excellency's question on whether the orders, Your Excellency, whether the orders amounted to effective control, if I got your question properly.
It was an order to storm infrastructure. Those civilian is not absolutely protected from attack, yes? Yes?
Yes.
So is it clear now?
Yes, it's clearer now, Your Excellencies. Yes. And we submit that in this particular case, the schools, radio stations, and hospitals were still civilian objects. And by virtue of him storming them, Your Excellencies, he was committing an intentional attack on civilian objects.
Are they absolutely protected under international law?
No, Your Excellency, they're not absolutely protected under international law. And where it can be demonstrated that they are military, or rather they are contributing to any military advantage, then they lose their civilian status for the period in which they are contributing to any military advantage. And this is seen in Article 52 of Additional Protocol 1, Your Excellencies. With this, I'd like to cede the floor to my co-counsel to proceed.
Please.
As previously introduced, my name is Alen Dulu, and I'm appearing as the second counsel for the prosecution on the matter. Of the 25 minutes graciously allocated, I shall take the next 15 minutes to dispense on the issues of the war crimes and subsequently address the prayers. Unless directed otherwise, I shall proceed. Your Honors, the matter before you is a grim reminder of Helmer's heinous acts that amount to the grave violations of the laws of war. As such, in pursuit of justice, the prosecution will demonstrate that Helmer is guilty of the war crimes we are charging him with today. On to our first submission, the prosecution submits that Helmer is guilty of directing attacks towards civilians under Article 82B1 of the Rome Statute. And we shall advance this in 3 limbs. First, that Helmer did direct an attack. Second, that the object of the attack was civilians. And third, that he did intend civilians to be the object of this attack. On to the first limb, the 2019 case of Prosecutor versus Tagada does state that one is considered to have directed an attack where they select the target and the mode of the attack. May I guide this honorable court to paragraph 44 of the fact pattern, where we can see Helma deploying the use of the autonomous weapon system, which is the AWS, onto the city of Kavo. As such, we do submit that Helma did in fact direct an attack. Onto our second limb, the prosecution submits that the object of the attack was in fact civilians. And this is because this AWS was indiscriminate in its effect. The AWS was programmed.
The programming was for a particular, to target a particular persons, not necessarily, just distinguish between the targeting and how that amounts to civilians.
Okay. The AWS was in fact programmed to target men taller than 1.6 meters, of robust build, and wearing a uniform. Your Honor, our uniform is not sufficient enough to distinguish between combatants and civilians. It could be a school uniform, it could be a police uniform, it could be construction uniform. Your Honor, additionally, the case of Prosecutor versus Taganda does state that where a weapon is deployed and it is incapable of distinguishing between civilians and combatants, it may be considered an attack towards civilians. As such, it is our submission that the object of the attack was in fact civilians.
Counsel, just a quick one for guidance. You mentioned about how atrocities violated the laws of war. May I request that you also address yourself to whether you find these atrocities as a violation to human rights law, and how? And I would like to also advise that your co-counsel spare some remarks for that. You continue mentioning that he is guilty, is guilty, is guilty. Isn't one innocent until proven guilty by a court of law?
And that's not why you are here. If you already declared him guilty, what are we doing here?
In response to your question about he is guilty, he is guilty, he is guilty, Your Honor, that is exactly what we want to demonstrate before this honorable court, that he did direct the attack, that he did intend the objects of the attack to be done in the context of war crimes, Your Honor. And the decision will be left to this honorable court. However, it is our conviction that Helma should be held responsible for the war crimes committed in Tivania. In response to your question about human rights, we do submit that human rights and international humanitarian law are separate legal entities. However, humanitarian law does step in where there is arbitrary deprivation of human rights. And as such, in our submission, as we will demonstrate, the attack onto civilians, the attack onto civilian objects and causing excessive incidental harm does in fact violate the principles of international humanitarian law and the principles under human rights, in which human rights are supposed to be inalienable and universal to everyone and not derogable, Your Honors. In proceeding with my arguments, onto the last list, I did in fact have the intent to the attacks towards civilians. Article 32B of the Rome Statute provides that a perpetrator has intent where the consequence of the outcome is said to happen in the ordinary course of events. Your Honors, may I guide this honorable court to paragraph 44 of the fact pattern, where it is clearly shown that Helma deployed drones for the sole reason of causing psychological panic. And this is something that has been prohibited under Article 51.2 of Additional Protocol 1.
I like something that you said. So when you talking about intent, and you further qualify and say in the ordinary course of events. When we had these devices deployed, it is also stated that there was malfunction. Would that be in the ordinary course of events?
Your Honor, it is our submission today that despite the algorithmic errors, or despite the errors that did plague the AWS, which is the autonomous weapon system, this attack on civilians would still have happened in the ordinary course of events. In our submission, we do state that the AWS was indiscriminate in its programming. As stated before, it was targeting people wearing a uniform. This is not sufficient enough to distinguish between civilians and combatants, which is required.
Counsel, it states that the autonomous weapon systems were programmed to only target specific types of people, making them more of a precision-guided weapons. And you are talking about the result of the raids. So what type of assessment are we expected to make, in particular within the principles of international humanitarian law, to hold a commander responsible?
In response to your question, paragraph 39 of the fact pattern does in fact state the programming of the AWS was set to attack the set type of people, which is taller than 1.6 meters, of robust build and wearing our uniform. Your Honor, it was not set to target specific people, and as such it is our submission that it was incapable of distinguishing between civilians and combatants. And in terms of that we ought to make today, we urge this court to look at the principle of precaution and the principle of proportionality, Your Honors.
Excuse me, Counsel. So now let's get to the principle of proportionality. What type of assessment do you expect the court to make today? Is it an assessment based on the facts after the attack?
No, Your Honor. In response, it is our submission that proportionality ought to be taken into account at the time of the attack. As such, the assessment being done by the court today should be one of the aim being sought by the government forces and the civilian harm being caused by the AWS.
Just a quick for guidance, Counsel, this is a court of law. I would like to advise you not to give much more of your opinion, but refer to sources of law as much as you can.
Your Honor, the source of proportionality was in fact stated in the 2014 case of Prosecutor versus Katanga, in which it was stated that the proportionality principle requires that incidental civilian harm should not be excessive of the military advantage. Your Honor, onto our second submission, the prosecution avers that Helma is guilty of directing attacks towards civilian objects under Article 82B2 of the Rome Statute. This will be advanced in 3 limbs. First, that the perpetrator directed an attack. Second, that the object of the attack was civilians. And third, that he did in fact intend to make the civilian objects the object of this attack. May I guide this honorable court to paragraph 44 of the fact pattern, where it is stated that Helma did in fact direct his troops to storm schools, medical centers, and hospitals, and as such, he did direct this attack. Onto our second limb, the prosecution submits that Helma did in fact make civilian objects the object of this attack. Your Honors, civilian objects is defined in Article 52 of the Additional Protocol 1, in which it is stated that civilian objects are objects which do not make an effective contribution to military gain, nor offer a definite military advantage. Your Honor, schools, medical centers, and radio
that's
stations.
The definition of a civilian. Is that the definition of a, are you properly quoting that article?
Yeah, yes, I am.
You sure?
Yes.
Continue.
Your Honor, as evidence in paragraph 44 of the fact pattern.
There are other paragraphs also, yes?
Yes, however, the storming of the schools, medical centers, and radio stations was done in this paragraph.
You have belabored it. So I'm just asking you to
All right.
focus on other things as well. Thank you.
On to our final limb, the prosecution does submit that Helma did in fact have the intent to subject civilian objects as the object of the attack. Your Honor, in the ordinary course of events...
Sorry, and we notice also that you're heavily mentioning schools and hospitals in the same breath. Do they have the same nature of protection? And also perhaps, I find it very interesting that as per the facts, the storming of schools and hospitals doesn't seem to be unique to one side. It's happening everywhere. It almost seems like it is the game. Storming schools, you're storming schools. Maybe we shouldn't pay regard to this anyway.
In response to your question, Your Honor, they do have protection. Schools and hospitals are protected under the additional protocol. However, hospitals and medical centers do have much more protection under the law rather than as compared to schools. It is our submission that the war crimes being committed by Helma in regards to the storming of schools, hospitals, and radio centers are ones that we can't provide evidence for before this honorable court, and as such, we do lay emphasis in the storming of these areas.
Casualties that are recorded in the scenario. I know that there's storming of schools and hospitals and whatnot. Are there recorded casualties, and does it matter if they were stormed but there were no casualties? Would it matter?
Your Honor, in response to your question, it does matter whether there were casualties, Your Honor. In regards to the storming of, in regards to the attack on civilian objects, paragraph 44 of the fact pattern does in fact state that numerous individuals were targeted. Individuals is a general term, Your Honor, and it is our submission that it could be addressing civilians or combatants. In the ordinary course of events, Your Honor, the storming of the schools, medical centers, and and radio stations would constitute an attack on civilian objects.
Just remind yourself what you needed to submit to us,
yes.
Okay?
Yes.
And see how much time you're left and whether you have enough time to submit on all those issues. There's so many other things we are expecting to hear from you. Thank you.
On to our final submission. The prosecution avers that Helma is guilty of causing excessive incidental harm to civilians. And in the advancement of this limb, we shall focus on Helma directing the attack, Helma focusing the attack, using an attack that would cause excessive incidental harm to civilians, and third, that he did have did use the AWS, which is the autonomous weapon system, and it was not sufficiently programmed to distinguish between civilians and combatants. As such, it is our submission that through the use of this autonomous weapon system, that there was excessive incidental harm towards civilians through the algorithmic errors caused, Your Honor. The defense prosecution's submission that regardless of the change in weather or the algorithmic errors, the AWS was in fact an indiscriminate weapon, and as such, it would have targeted civilians.
Counsel, we're talking about autonomous weapon systems, meaning weapon systems that make decisions on targeting and striking on their own. So why are you asking for this court to hold Colonel Helma responsible for decisions made by the weapons themselves?
Your Honor, in response to your question, there might be an accountability gap in the use of the AWS, which is the autonomous weapon system. However, in pursuit of justice, we need to hold the person who did in fact direct these attacks or did use the indiscriminate weapon accountable for the loss of lives. As such, regardless of the algorithmic errors, it is our submission, Your Honor, that Helma is guilty of using an indiscriminate weapon, and it did cause excessive incidental harm. On to our final limb, the prosecution avers that Helma did intend to use an attack that would cause excessive incidental harm to civilians, and this is due to the use of this indiscriminate weapon, which is the autonomous weapon system. And in conclusion...
Hang on. The incidental harm, could you please describe that? And before you conclude entirely, I would like to, bring you back to the complementarity between IHL and human rights. And in particular, I would like you to come up with, guide the bench with particular instruments, provisions, or any other sources of law regarding to any human rights violations that came from summary execution, sexual torture, mass arrest, and storming of radio stations. You don't have to finish all that. You can just divide it between you and co-counsels, but I would like you to touch up on how human rights violations, or rather human rights law is violated with these atrocities.
In response to your question, Your Honor, the commentary of the Rome Statute did in fact describe indiscriminate weapons, did in fact describe incidental harm as a harm that does occur as a result of an attack.
Provision?
I may not have the provision with me, however, it is stated in the commentary as a definition under Article A2B4 of the Rome Statute. Your Honor, in response to your second question as to the complementarity of international humanitarian law and human rights with regards to sexual torture, summary executions, and rape, if I got your question correctly, I shall address in regards to torture, then I shall hand over to my co-counsel to address on rape and summary executions. Your Honor, human rights are...
Remember, you're left with just about 4 minutes for both of you. Thank you.
Your Honor, human rights are stipulated under the ICCPR and the African Charter of the Human Rights, which have in fact been ratified by this state today. As such, it is our submission that these rights are non-derogable, especially when it comes to torture.
Just to confirm, which instruments were you referring to? ICCPR?
The ICCPR and the African Charter of the Human and People's Rights. Your Honor, the freedom from torture is a just cogence norm, and as such, it should not be derogated at any point. In relation to human rights, in relation to international humanitarian law does in fact protect people from torture, and it is stipulated under the Rome Statute and under the additional protocols. In conclusion, failing responsible would be tantamount to being complicit and in support of the suffering of the People's Republic of Tivania. And as such, the prosecution does pray that you do find Helma guilty under Article 82B1, 2, and 4 of the Rome Statute, that you find him criminally responsible under Article 28A of the Rome Statute, and that you do classify this conflict in terms of an international armed conflict. Much obliged.
I think there's a question directed to you, so you have 2 minutes to present that. It's still part of your presentation. Thank you.
Your Excellency, just for clarity, is this within the 25 minutes of our submissions, or?
It's part of the 25 of your submission.
25 of our submissions?
Yes.
Okay, so the rebuttals are not counted for this?
You have time for rebuttal, so okay. Just go on, yes.
Thank you for the clarification.
The issues that arose that have been asked, and yeah, please.
Yes. So I believe Honorable Irene asked a question on human rights in this particular context. And Your Excellency, we do note that the rapes, or rather rape was used as a form of sexual torture, and this, Your Excellencies, violates the freedom from torture that is a jus cogens norm and is guaranteed under Article 7 of the ICCPR. And in regards to summary executions, Your Excellency, we submit that the summary executions do amount to an arbitrary deprivation of the right to life, violating Article 6 and Article 6 of the ICCPR and Article 4 of the African Charter on Human and People's Rights.
Any other crimes you prefer against Drex that you've not addressed and would want to address?
Yes, Your Excellency, there are other crimes such as rape, but in this particular context, we do not charge Commander Helma with rape, as rather all the elements of the war crime of rape under Article 82B20 have not been proved. And Your Excellency, we came to this conclusion by virtue of the fact that we only see a report detailing that rape occurred, but for rape to be charged as a war crime, we need to see the penetration, Your Excellency, and in this particular case, the reports do not suffice to indicate that this particular penetration occurred.
It relates to cybercrime in this instance.
We do note your concern, Your Excellency, but Helma's forces did not commit any cybercrimes. The cybercrimes are...
Together with my co-counsel, Christine Miruka, I will take 12 minutes of the 25 minutes allocated to address issues on whether war crimes were committed, as well as issue on whether Colonel Drax Helma had effective control during Operation Tosuma. My co-counsel, Ms. Miruka, will take 13 minutes to address the question of whether Colonel Drax Helma knew about the war crimes alleged to have been committed during operation, and ultimately whether Colonel Drax Helma failed to take measures of punishing those who have perpetrated this crime. I beg to start my submission. Thank you so much. The defense would like to concede that first, the war in Tivania was an IAC. However, it later on internationalized to an IAC. This is assessed on the test that was expounded in the Tadic case, the overall control test. Support in its nature may be direct or indirect. In this extent, the support provided by the state of Ksenia to groups such as Airlis sufficed this war to be an IAC. I now beg to proceed whether war crimes were committed. The first.
Just to expound on what led to the internationalization of the armed conflict, please.
Thank you for that clarification.
And I also want to ask that just give us what definition you have of what NIAC is. You have a definition under international in the treaties, or we are only limited to the case decision. Thank you.
Thank you so much for that. First, the war is internationalized to IAC, and I make reference to paragraph 23 of the compromise, whereby there is support provided by the state of Ksenia to groups such as Airlis, and there are cyber drones which can be attributed with serial numbers with the parastatal that is linked to the Ministry of Defense in Ksenia. To this extent, these meet the test of indirect control, hence it suffices the conflict to be an international armed conflict. In regard to definition, yes.
Provision of weapons is enough.
Yes, provision of weapons
is enough.
Yes, and other logistical support that was provided.
Okay, continue.
Thank you for that. I beg now to proceed and provide a definition that is provided under Rule 156 of the ICRC. An international armed conflict. The International Committee on Red Cross.
And why is it relevant to us as a court?
I rely on it to provide a definition on what is an international armed conflict. Yes.
Where is it located? What is the rule? Where can we find the rule?
Indulge me for that, my lady.
You stated Rule 156 of the ICRC, the International Committee of the Red Cross.
Yes.
From my limited knowledge, the International Committee of the Red Cross is a humanitarian body.
Yes.
Where do I find the rule? Where is it? What is it in?
I may not have the rule.
Okay, proceed.
Allow me now proceed with the substantive issues. The first substantive issue presented is, were war crimes committed during Operation Tosuma? The first issue we present before this court is to assess the nature of Operation Tosuma. First, Colonel Drax Helmer is appointed, provided under paragraph 39 of the fact pattern. His appointment was to ensure there was the restoration of Republican order. To this extent, under paragraph 40 of the fact pattern, Colonel Drax Helmer proceeds to craft what is the way in which they are going to establish this. Establishment of this map, the enemy zones. And this suffices to meet the test of distinction. I will expound later on the same. Number two.
Counsel, let me ask you.
I mean, civilians not to be attacked during this operation. I now proceed. What are some of the measures that he took to ensure that civilians were not targeted during Operation Tosuma? One of them is to first map the enemy zones, and this is provided under paragraph 40 of the fact pattern.
Yes, the paragraph pattern shows that, but what law kind of supports that? Could you please make sure that you guide this bench to the law, sources of law, so that we can be able to deliberate correctly? When you give an opinion or the facts, that's okay, we both have those. But what about the law? Because you're not going to be able to make a deliberation on opinions and facts, right?
Yes. Thank you so much for seeking that clarification. My lady, Article 48 of the Additional Protocol 1 establishes the principle of distinction. And it establishes that during war, civilians should not be targeted. And to this extent, we assess this to paragraph 40. What are some of the measures Colonel Drax-Helmer took to ensure that principle of distinction was adhered to? One, they first mapped the enemy zones. And number two, the attack were based on precision. And number three, they had programmed the drones to select and target those who are in uniform. I will expound this later on. I now proceed to supplement it with the precautionary principle. The precautionary principle is provided under Article 57 of the Additional Protocol 1. And under the precautionary principle, Colonel Drax-Helmer is also obliged to extinguish civilians from combatants. To this extent, I now proceed in the nature of orders which were given. The nature of orders given were direct, they were explicit orders. However, these orders in any way did not affect the civilians. In what context? Colonel Drax-Helmer had first formalized a structure to identify the enemy zones. And the enemy zones, to this extent, the areas that had been attacked were civilian objects, and they had lost protection under international humanitarian law. This is provided under Article 51 of...
You are explaining my question, and then just go on, please.
This is provided under Article 51 of the Additional Protocol 1.
Which provides that?
Okay, thank you so much.
Yeah.
Additional Protocol, Article 51 of the Additional Protocol 1 requires Colonel Drax-Helmer to extinguish civilian objects from military objectives. To this extent...
Council, apologies for interrupting you, but can you point to where it is stated in the fact sheet where the defendant giving direct orders to storm civilian objects, schools, hospitals, you name it, where they say that those same objects or infrastructure were being used by soldiers, by the enemy soldiers?
Thank you for seeking that clarification. The first objective as established was to map the enemy zones. After mapping the enemy zones, it had been established, it can be inferred that it was established that indeed these civilian objects...
No, just take us to the facts.
Thank you.
Just tell us on this paragraph, this happened, and that's why they lost their protection as civilian objects.
Thank
Is there
you so
any fact you can refer us to?
Paragraph 40 of the fact pattern states that reports indicate that the drone strikes had occurred. However, government drones were dispatched to map enemy positions and provide targeted support to ground forces. I now proceed in the nature of the orders that were given as provided under paragraph 44. Paragraph 44 reads, supported by government armed forces already present in the town and taking advantage on the opening of the Airlist and PMLT, the operation aimed for total domination through terror. However, the attacks were based on precision. And to this extent, precision, they were accurate and in any way did not affect the civilians.
Just read the last thing you read there. The very last thing before you explained. The attacks were aimed at?
The operation aimed for total domination.
Mapping.
Yes.
Okay. Please, you invite us to ask you questions, but we want to ask you that we are going to, let me ask the bench to refrain as much as possible so that we listen to you, then we will ask questions. Please.
Thank you so much. Yeah. I now proceed to the credibility of the evidence presented before this court. The prosecution heavily relies on paragraph 44 and 45 to present their case. Number one, On paragraph 45, on the alleged summary executions, the report is provided by a local NGO in the region, that is iPeace. To this extent, Article 69 of the Rome Statute provides two tests in regard to admissibility of evidence. Number one, evidence must be clear, and number two, evidence has to be of probative value. In the case of Bagilishema, the ICTR held that in instance of conviction, the evidence presented before the court has to be substantiated. It is our submission that the prosecution has not substantiated evidence in regard to the NGO reports that allege on summary execution as well as rapes. This was also maintained in the Christic appeal case by the ICTY as well as the Halilovic case by the ICTY on the credibility of evidence being substantial, reliable, and clear. I beg now to proceed on the issue of command responsibility.
We can't help ourselves, but...
Yeah, I'll make it short. Then, because you stated, you're submitting that indeed the iPeace report should be corroborated, do you have any other piece of evidence that corroborates that report?
There's no such evidence. That's why they're rejecting it. Their defense. Yes, thank you.
Thank you for that. We maintain our position as held in Bagilishema case, whereby Baligishema, who had been charged for perpetrating genocide in Rwanda, was acquitted based on one, he had distinguished and took all precautions during the operation that was being conducted. Number two, that the evidence that was presented before the court could not be admitted because it was not clear as well as relevant to the case. I now proceed to the issue on command responsibility. Thank you. The case presented before us is that Colonel Draxelma had effective control over the troops during the operation. Okay. Okay, thank you. I now proceed to the issue on effective control during the operation. We submit that Colonel Draxelma did not have effective control over the PMLT forces. However, he had effective control over the government forces. Colonel Elma, to be charged and convicted of the crimes presented, it must be shown that he had the mental element awareness in regard to the crimes that were committed. As a commander, he is required to must have had the knowledge. Knowledge is defined under Article 30, Sub-Article 3 of the Rome Statute. It is defined as awareness that a circumstance exists or consequence will occur in the ordinary. That a circumstance exists.
Sir, with or without evidence, so someone can order particular atrocities or attacks to be done, but they would not have awareness that the atrocities are going to be done.
Thank you, Your Ladyship, for that question. To respond to your answer, we have submitted that Colonel Draxelma did not perpetrate war crimes. To this extent, we now proceed, was he aware about or had effective control about what was being conducted by the PMLT forces? The PMLT forces occupied the northern east part of Kovu, whereas Colonel Draxelma and his troops.
I beg that you do not make an argument on his control over the PMLT because that isn't in contention. Let's look at where he has control, yes.
Thank you. As submitted, Colonel Drax-Selma had control over the government forces only. I now proceed to assess the issue on effective control. In assessing effective control, I will use de facto and de jure threshold in assessing it. The de jure and de facto control was assessed in the Bemba case. For Colonel Drax-Selma to be criminally held liable, he must have both de facto and the de jure authority over the troops on the ground. Number one, is it possible for the court to only admit one threshold? Our submission is that no. The court is required to admit both thresholds on de jure and de facto authority. I proceed. Colonel Drax-Selma had de jure authority, specifically in general, over both armed forces, because there was an agreement between Airlist and between PMLT as well as government forces. But now we proceed to assess the situation on the ground, on de facto. The fact on the ground is that there is simultaneous operation that is also being conducted by troops such as PMLT, and this failed to suffice that he had control over those troops. Under paragraph 42 of the fact pattern, it is raised that NGOs raise issue in regard of mode of methods of war that are being used by PMLT. To this extent, it can also be attributed that the alleged crimes could have been committed by PMLT. To proceed, first, Elmer is required to have known that his troops were committed the crimes. Knowledge cannot be presumed. And this was also held in a Lilovic trial case, whereby it was held that under paragraph 66, and it emphasized that knowledge cannot be presumed. The prosecution submit that it cannot be presumed that Colonel Drax-Selma, based on de facto authority, had knowledge that the PMLT, which he had the de jure authority over, were committing these offenses. I now proceed on matter of autonomous weapons. In the Bemba case...
Is there something that was being done by the government forces? Sorry if I'm being very pedantic, but is there atrocities that were being committed by government forces? It seems like in your argument, the core of your argument is that you must be banning PMLT and not Colonel Helmer, right?
Yes.
But the scenario as it is, we see that some of them were being done by the government forces. Or are we missing something?
Thank you for that question, my lord. To answer you, as submitted earlier on, the government forces had taken all precautionary measures based on distinguishing civilians from combatants, and these atrocities cannot be attributed to the government forces.
Council, sorry for interrupting. I want you to go back a little bit to the mens rea. You're denying the actual knowledge. The defendant being part of the armed forces of the government, what if we explore the constructive knowledge? Because under the normal circumstances, he would have been able to make due diligence and know what was happening with the subordinate.
In addition to that, Council, this is a court of law, and as a court of law, the final decision rests upon us. So whether or not we accept your arguments that these crimes were committed or not is something that we are going to use to weigh the case brought by the prosecution, weigh the case brought by you as the defendants, and then make a decision. Therefore, you still would have to make arguments based on either the effective control, the knowledge, and the failure to prevent or to punish of Colonel Helmer on the basis of the war crimes that you have been submitting, well, that they have not been committed still.
Thank you for that. I will answer you based on Bemba case. In Bemba case, it was stated that if a superior has exercised due diligence in the duties and still lacks knowledge, they cannot be held liable. Colonel Drax Helmer exercised due diligence over his troops. His operation took all precautionary measures, and he cannot be held liable of acts that were committed by the PMLT forces.
Very well. We direct that we listen to you to the end. Then any other questions we'll bring afterwards. Okay. So how much more time do you? How much more have you presented? Okay, please. You're done? You're done with the submission, yes? I'm not asking you to leave this stage. I just want to be sure that you're done.
I was not done. I've seen it 15 minutes remain, so I thought that you were saying that you have heard me. Sorry for that.
No. I'm just saying, are you done? Just finalize the
I would like to finalize on an issue on autonomous weapons.
Please.
Thank you for that. On the issue of autonomous weapons, we'd like to assess the situation still on Bemba case. In Bemba case, it was stated that commanders in acts that cannot be foreseeable, they cannot be held liable. In regards to the autonomous weapons, these acts were unforeseeable, and to this extent, Colonel Drax Helmer cannot be directly attributed to autonomous weapons, which can be subjected to technical bias as well as malfunctions. Hence, we submit that the autonomous weapons cannot be used as an evidence of credibility and cannot be admissible before this court to convict Colonel Drax Helmer of having committed war crimes during Operation Tosuma. I'd now like to invite my co-counsel to assess the situation on whether Colonel Drax Helmer had the knowledge or failed to take precautionary measures and failed to punish the perpetrators. Thank you.
May it please this honorable court, for the purposes of record, my name is Miruka Christine. I appear as the second counsel for the defense. I fully associate myself with the submissions made by the lead counsel. Having demonstrated that Colonel Drax Helmer had no effective control or command over the perpetrators of the alleged war crimes, the defense proceeds to make submissions on the test and Article 28, paragraph 1 of the Rome Statute. That is, first, whether he knew or should have known, owing to the circumstances at the time, that war crimes were being committed. And second, whether he failed to prevent or punish the war crimes, or even submit them to competent authorities for investigation or prosecution. I beg to proceed. To start with, the issue whether he knew or he should have known is anchored under the mental element, and therefore it is the submission of the defense that at this point the honorable court should assess whether Colonel Drax Helmer had menstruation over such. Article 30, paragraph 3 of the Rome Statute provides for mental element, and it defines knowledge as awareness that a circumstance exists, or as a consequence it will occur in the ordinary course of events. The defense submits before this honorable court that Colonel Drax Helmer had no knowledge of the same. And why is this the case? The first question under this issue is, did he know of such crimes? To the factual background, as demonstrated by the lead counsel, Colonel Drax Helmer had no effective control or command. It was established in the celibacy case in the appeal chambers, specifically under paragraph by the appeal chambers, that without effective control, there can be no knowledge of such acts being committed. In this case, Colonel Drax Helmer had no effective command or control. Therefore, it cannot be adduced that he knew of such acts being committed. Secondly, that he took precautionary measures to ensure that such crimes should not be committed. As we make reliance on the case of Bemba, that in the instance where a superior takes due diligence and still lacks knowledge, he should not be held liable for any acts being committed. We further the defense makes further submissions With regards to the second question that arises under...
Excuse me.
Thank you.
Just to clarify, who did he not have effective control over?
The defense submits that Colonel Drax-Helmer had no effective control and command over perpetrators of the alleged war crimes.
Which ones? Is it the PMLT or is it the government forces? But I sense that you have argued that there has been no crimes committed by the government forces. So which ones did he not have effective control over?
Colonel Drax-Helmer had no effective control over the government forces and also the PMLT.
Sorry, in addition to that bit, could you please guide this bench, because it's a little bit confusing. As the prosecutor has alluded, there are sections on the factual case that directly indicate that there were direct orders from Drax to his, how do you call it, the command to go to do the attacks, right? But you're detaching that because of effective control. Could you please advise this bench on how to really detach with you those two aspects? How do you disassociate the Drax orders from the control? You know what I mean? There's a confusion here.
Thank you for that question, Your Ladyship. The defense proceeds to give an answer to that question by making reference to the Ademi and Iraq case. The trial panel, in assessing the case under...
just the facts. The facts. Answer based on the facts.
Thank you for that.
Look at paragraph 44, 45, 39. And just on the facts, we will deal with the law. Thank you.
Thank you for that clarification. Orders, the defense submits that orders were given under paragraph 45, paragraph 44.
Who gave the orders?
Colonel Drax-Helmer gave orders.
Is that not control?
I will answer that by making reference to the previous facts before paragraph 44, whereby Colonel Drax-Helmer, by giving orders, he is giving orders on how Operation Tasuma is to be conducted, not on any attack, as he had taken precautionary measures as to such. And as such, the defense makes reference to the Ademi and Iraq case, whereby the trial panel held that a commander is the guarantor of proper conduct of operation by his units. And in this case, that, as the court emphasized, that he should ensure compliance with international humanitarian law. In this case, we see that Colonel Drax-Helmer had taken precautionary measures which are cardinal principles under international humanitarian law. As such, we can see that he had no control or command over any perpetrations of these acts. I will address the second question that is important for us to address under this issue. Did the circumstances at this time give reason that Colonel Drax-Helmer should have known? The defense makes reference to the Hadzi Hazanovic case, where the appeal chambers held that, information that gives the commander reason to know should be sufficiently enough to provide an alarming risk of such acts. The prosecution, and also, another point to this, which the defense makes submission on, is that we cannot rely on such information to presume knowledge, as seen in the trial judgment of Hadzi Hazanovic, particularly in paragraph 1223. It is a general rule that rumors or general reports are insufficient to establish knowledge. In this case, taking his appraisal as a reliable... Yes?
You have directed us to paragraph 47. And in his letter to the troops, what does he say? He's likening their actions to legitimate reprisals against perceived affront by iPeace. Does international law accept reprisals, whether legitimate or not?
the defense seeks your guidance.
Proceed, please.
Thank you for that. The Bemba case emphasized under paragraphs 427 to paragraphs 434 that in instances whereby a superior takes due diligence and still lacks knowledge, he should not be held liable for the same, for the committing of such acts. And in this case, in assessment of this case at hand, whereby assessing mens rea, this court should not place reliance on ex post facto knowledge, but on the mens rea, as was emphasized by the ICC in the Bemba case. Unless there is any further question, the defense seeks to proceed to the issue whether he failed to prevent or punish. In addressing this issue, the defense takes two limbs on the same. First, that Colonel Drax-Helmer took necessary measures to prevent, and secondly, that Colonel Drax-Helmer did not have reasonable, owing to the circumstances, he did not have material ability to take any reasonable measures to punish. First, in the Bemba case, it was established by the trial panel that necessary measures are measures that are appropriate to establish, to enable the superior to discharge his duties. As presented earlier, Colonel Drax-Helmer took such measures to ensure that there is prevention of such acts being committed. And as emphasized in the Ademi and Orak case, that as a guarantor of the proper conduct of an operation, he should ensure compliance with the international humanitarian law, which is complied with at this point. The defense also makes reference to the case of Bemba, whereby in paragraphs 435 to paragraph 442, that necessary measures to be taken are measures within the material possibilities of the superior. In this case, we see that Colonel Drax-Helmer did not have any material possibilities, that he did not have any institutional or legal mandate to take any other measures, as he was only the commander of Operation Tasuma. As such, Colonel Drax-Helmer, after taking precautionary measures, there was no other measures he could take to prevent such acts that were perpetrated. Further, in addressing that Colonel Drax-Helmer did not fail by failing to punish, did not commit the crime, should not be subjected or should not be held liable under superior responsibility by failing to punish the perpetrators. First, the defense makes submission that the only information or reports that the defense places reliance on for Colonel Drax-Helmer's knowledge is under paragraph 47, whereby there is a letter detailing atrocities of the commissioning of acts. However, at this point, his command had come to an end. A threshold is established in the Stupa et al. Case under paragraph 35, that whereby a superior ceases to have authority over perpetrators of acts, he ceases to become their superior. In this case, we see that Colonel Drax-Helmer takes no operation after Operation Tasuma, that the authority remains hierarchical to the headquarters in Euralia. In this case, the alternative provided in Article 28(1) of the Rome Statute, that he should have punished, does not apply to Colonel Drax-Helmer, as it is upon the superiors to take such measures to punish. In the case of Ademi and Orak, Ademi was acquitted even after he had knowledge, since the superiors were to punish. Such acts were presented to the superior authorities, however, no measures were taken. In this case, when the letter was given to Colonel Drax-Helmer, the President and the Ministry of Defense were aware, however, they took no measures. Colonel Drax-Helmer was not in a position to take any such measures at this point.
Cool. Thank you so much for all that. I just wanted for your team to take these less than 5 minutes, like per 4 minutes, right? To associate, we all agree that there are some crimes perpetrated in this case, right? I just wanted you to associate those atrocities with human rights law. So whether you deny or you agree that your client did those atrocities, could you perhaps pick at least 2, 3 atrocities or violated rights and associate them with particular specific instruments or specific rights, human rights under international human rights law? You could divide the time among yourselves, but I would like to hear your remarks regarding the complementarity between IHL and human rights in the case. Is that okay?
Thank you. To begin with, international human rights law is complementing to the international humanitarian law principles, as was as seen in the commentary number 36 of the Human Rights Committee. With regards to that, the human rights that are affected by by atrocities in such conflicts, first is the right to life under the International Convention for Civil and Political Rights, which provides that such right is non-derogable. In this case, during such conflict, there are deaths of civilians that took place. In this case, this right is violated. With regard to international humanitarian law principles, there is Article 48 of Additional Protocol 1 to the Geneva Conventions requires that parties distinguish civilians from combatants. However, during this conflict, we see that there is no distinction to some extent, whereby there are civilians who are affected in the same. With regard to the principle of proportionality, there is a requirement that there is a prohibition to indiscriminate attacks, which in the case of the defense, Colonel Drax-Helmer did not take measures to ensure that such doesn't take place. A proper reading of Article 51.4 of the additional protocol is that indiscriminate attacks are those which are not directed at a specific military objectives, and that those which employ a method or measures of the combat which cannot be directed to such. We see measures taken here to ensure that such is adhered to.
Very well. Gone. There's a question to the co-counsel, and you have less than 2 minutes left. So are you done? Are you done? Oh.
Yes.
Are you done? Your submission, are you done with the submission now?
The defense would like to make its prayers before this honorable court.
We have the prayers with us. Just the co-counsel to answer that particular question, please. Very well.
Thank you.
And you have 2 minutes, please. Or less than 2 minutes, but we'll give you 2 minutes at more.
Thank you. The question. Thank you. There are 3 cardinal treaties on human rights: the Universal Declaration of Human Rights, the International Convention on Civil and Political Rights, the International Convention on Economic, Social, and Cultural Rights. I link them to the international humanitarian law principles. In any time during an armed conflict, it is a requirement that international humanitarian law principles are adhered to. 1 is the principle of distinction. 2, the proportionality principle and precautionary principle. The prosecution submit that in the presence of groups such as PMLT on the ground, as provided under paragraph 42 of the compromise, whereby NGOs raised issues in regard to the methods that they were using during war, this could have led to violation of rights such as right to life enshrined at Article 6 of the ICCPR. However, we submit that Colonel Drax-Helmer in any way did not violate the international humanitarian law, international human rights law, because he adhered to the cardinal principles of the international humanitarian law. We humbly submit.
Well, thank you. Thank you very much. Now, we have come to a time when because you reserved 5 minutes for rebuttals, and this is how we wish. I'll urge the bench to listen as you rebut, but it's only rebuttals. It should be in this manner. The prosecution submitted as such. We have this opinion, or we have this position. And that would be it. So it's up to 5 minutes, but it doesn't have to get to 5 minutes. Thank you. Applicants.
Presiding judge, honorable judges, may it please this honorable court, good morning once again. As earlier introduced, I am Lomole Janathan, rising as first counsel on behalf of the prosecution for 3 points of rebuttals. But before we dive into rebuttals, I'd like to highlight that today it is Colonel Helmer who is on trial, not General Volker of the PMLT forces. And as such, we are charging Colonel Helmer for the war crimes that his troops committed. I begin with the first point of rebuttal, where the defense explicitly stated that Commander Helmer had no effective control and command over his troops, and they rightly quoted the Bemba decision. However, Your Excellencies, may I guide you once again to the Bemba decision, where the court laid out various factors in determining whether a commander has effective control and command over his troops. And some of these factors were his power to issue orders, his power to send troops to various places, and his position within the military hierarchy. In this particular case, Your Excellencies, there was effective control and command of Commander Helmer over his troops through his power to issue orders, as is seen in paragraph 44, when he ordered them to storm civilian objects, his power to send them to various places, where he sends them to the cities of Solvia and other cities, and his position within the military hierarchy as he was the commander in charge of Operation Soma. On to the second point of rebuttal, Your Excellencies, the defense submits that Commander Helmer was in no position to take necessary and reasonable measures to investigate and prosecute these particular crimes. And they rightly quoted once again the Bemba decision, Your Excellencies. But may I guide you to the Bemba decision, Your Excellencies, where the appeals court overturned the trial judgment's position in Bemba failing to take necessary and reasonable measures. And they found that Bemba did indeed take necessary and reasonable measures through his Mondonga inquiry, court-martialing people who had committed crimes, and the Zongo commissions. In that particular case, Your Excellencies, at least Mr. Bemba tried to take necessary and reasonable measures. But in this particular case, as is evident in paragraph 47, even to blind Bartimeus, Helmer took no necessary and reasonable measures. And paragraph 47 goes on to state other measures that he could have taken, such as investigating these things, internal sanctions, Your Excellencies, and disciplinary measures. And he did not take any of them when he had the power to do that. And on the last point of rebuttal, Your Excellencies, the defense has noted that Commander Helmer took precautions to ensure that civilians are not affected. May I guide you to Article 57 of Additional Protocol 1 that states whenever one is carrying out an attack, all necessary and feasible precautions ought to be taken. With this in mind, Your Excellencies, let us go to paragraph 44 of the record, where Commander Helmer launches Operation Soma with one objective in mind, to cause terror, and he uses his drones to cause panic. Your Excellencies, as is stated in Article 52(1) of Additional Protocol 1, causing terror among civilians does constitute an attack on civilians. As such, Your Excellencies, we submit that Helmer did indeed intentionally direct attack against civilians. Your Excellencies, as we come to the end of our submissions, and as you retreat to your chambers to consider submissions, we'd like to highlight one last thing. Throughout history, it has been the silence of the voice of justice when it mattered the most that allowed evil to triumph. Your Excellencies, today, you being the voice of justice, I ask you one question. Will you rise to the occasion, be loud, and hold Commander Helmer responsible for the war crimes committed by his troops? Or will you be silent and complicit in his odious, atrocious, and abhorrent acts? Thank you for your time.
Counsel, you're saying that whatever if we decide against your position, then we'll be complicit. Interesting. Very well, thank you. We have heard you. We welcome defense, please. Thank you.
Thank you, Honorable Bench. Once again, I appear, Miruka Christine. The defense would like to make its rebuttals. First, under effective command and control. It was raised that the algorithmic errors by the autonomous weapons used by Colonel Drax Helmer caused the autonomous weapon caused attack to civilians as they did not take place as targeted. We make reference to the Hadzi Hassanovic case held by the ICTY, whereby it was held that in the ICTY, it was held that commander should not be held strictly liable for acts taken. In this case, he should know, Colonel Draxelmar is not expected to know of the malfunctioning of such algorithmic errors. And also, the perpetrators that were under his command, if this court holds so, that this superior responsibility is not a strict liability. In this case, Colonel Draxelmar should not be held liable for the malfunctioning of algorithmic errors and also for any wrong misconduct of his subordinates. Secondly, it was raised that there was a concern by the prosecution over knowledge over the acts that were being perpetrated. In this case, we make reference to the Bemba case, whereby we invite this court in assessing the mainstay of Colonel Draxelmar that this court does not place reliance on ex post facto knowledge. As for the case of the defense, the only point at which Colonel Draxelmar gets a factual or a formal report of the atrocities is after his command authority comes to an end. The trial panel in the Bemba case, the appeal chamber in the Bemba case, outruled the holding of the trial panel, whereby they relied on ex post facto knowledge and not assessment of the mens rea. Thirdly, there was a concern raised by the prosecution under the intent of Colonel Draxelmar. The defense invites this court to take guidance of Article 30, Paragraph 2 of the Rome Statute, which provides for intent and knowledge. And it provides that there is intent where the superior, with regards to conduct, he intended to commit such conduct. In regards to consequences, he was aware that such consequences would occur and that he intended to let them occur. In this case, we see Colonel Draxelmar taking measures to ensure that such acts do not take place. In this case, there can be no intent adduced over the same, and there can be no knowledge adduced over the same, as it is construed under paragraph 3 of Article 30 of the Rome Statute, that know and knowingly shall be construed to mean as provided, which is knowledge of awareness that the circumstances exist, and that as a consequence, they will occur in the ordinary course of the events. It is the submission of the defense that Colonel Draxelmar had no awareness of any circumstances of these acts being committed, or that as a consequence they would occur. Further, ultimately, the defense invites this court to take the guidance of the threshold established in the Stupa et al. Case in paragraph 35, that there exists a threshold that the authority of the superior comes to an end whereby he does not have any command or control over perpetrators. In this case, the defense invites this honorable court that Colonel Draxelmar should not be held liable for acts. As first, he took measures to ensure that such acts do not take place, and that he had no actual or constructive knowledge of such acts being committed. And even at the point that he got such knowledge of such acts being committed, his command had come to an end. And therefore, we invite this court to take the guidance of Ademi Onorak case, whereby Ademi was acquitted for, despite having knowledge, he had no authority to punish. Colonel Draxelmar, despite having knowledge at the very end, he had no authority or material ability to punish. Thank you, Your Honorable Court. The defense asks that you consider our case.
Thank you very much. We have come to the end of these proceedings today. We commit to, let me take this opportunity to thank all the councils. The work that goes into, as officers of the court, you have come here to help inform a decision that is important. And we assure you that we are agents of justice and not impunity. And if we engaged you as much as we did. That just tells you that you're very exciting in your submissions, and therefore then we had to engage you as we did. Other than that, we will retire to consider your submissions, and then we'll come back to give a direction. Otherwise, thank you very much. The court stands adjourned. Thank you.
Hello, we are continuing with the second
Cour d'assises de l'État fédéral du Velmora est appelée aujourd'hui à connaître l'affaire du procureur-colonel Drax Elmore. Les parties présentes sont les ministères publics représentés par l'équipe du procureur et la défense du colonel Drax Elmore. La Cour entendra successivement les observations du ministère public puis celles de la défense.
Bien, monsieur le président du programme, cher professeur Elvis, chers collègues, chers étudiants et instructeurs, l'audience est ouverte. Permettez-moi d'abord de dire que je suis, en tant qu'expert invité au programme, mais aussi en tant que président du réseau francophone de droit international, très honoré d'avoir été invité à présider la finale francophone de la 10e édition du concours de plaidoirie des Grands Lacs. J'ai la chance d'être accompagné par un jury international d'experts composé du professeur Yves Mouiré de l'Université du Rwanda, de la professeure Catherine Maya de l'Université lusophone au Portugal, du professeur Trésor Maéché Mussolé de l'Université catholique de Bukavu en RDC, du professeur Benjamin Traoré de l'Université Mohamed VI Polytechnique à Rabat au Maroc, de la professeure Aurélie Tardieu de l'Université Caen Normandie en France et de monsieur Evaristus Ngorand du Haut Commissariat aux droits de l'homme aux Nations Unies au Rwanda et moi-même, professeur Raphaël Morel de l'Université Bourgogne-Europe en France. Avant d'entendre les plaidoiries des deux équipes finalistes, je saisis l'occasion qui nous est donnée de féliciter sincèrement l'ensemble des équipes participantes au concours. Nous avons cette semaine, je crois, entendu des plaidoiries remarquables. Et même si seules deux équipes francophones accèdent à la finale, vous devez toutes et tous avoir conscience qu'en participant, vous avez déjà gagné. Au-delà même des grandes compétences en droit international que vous avez acquises en travaillant dur jusqu'à aujourd'hui, ce concours est un ciment, je crois, de l'amitié entre les peuples de la région des Grands Lacs et crée un réseau international unique. Et donc ce programme auquel vous avez eu la chance de participer contribue à l'évidence à la paix et à la sécurité internationale, comme au développement harmonieux des peuples de la région. Et je tenais à rendre hommage à ces initiateurs et ces organisateurs. Ceci étant dit, la Cour d'assises de l'État fédéral de Velmora est aujourd'hui réunie pour entendre les observations orales des parties dans l'affaire des crimes graves commis en République populaire de Tirvania. La Cour rappelle qu'elle a décidé qu'elle était compétente, que la requête était recevable, de sorte qu'il est attendu des parties qu'elle plaide uniquement sur le fond. La partie représentant le bureau du procureur disposera de 25 minutes à répartir le plus équitablement possible entre les deux plaideurs, pendant lesquelles des questions pourront être posées par les juges. La partie défenderesse disposera du même temps dans les mêmes conditions. Les juges sont invités à poser des questions courtes et précises afin de permettre aux parties d'exposer leurs arguments dans le temps imparti. La demande disposera ensuite de 5 minutes de réplique pendant lesquelles aucune question ne sera posée, puis la défense disposera également de 5 minutes de duplique sans question. Sans plus tarder, j'appelle à la barre la première personne représentant le bureau du procureur. Maître, vous avez la parole.
Monsieur le Président, honorables membres de la Cour, le bureau du procureur ici est représenté par M. Gédon Kalonji et moi-même, Madame Sagesse Omari. Merci, Monsieur le Président.
Merci, Monsieur le Président, pour la parole. Le procureur présentera ses observations de droit eu égard des exactions.
Montez un petit peu le micro. Non, juste bougez-le vers vous. Okay, voilà, comme ça, okay. Exactement. Très bien, merci.
Eu égard des exactions perpétrées pendant l'opération Tassouma en Tirvania, de la période allant du 4 au 15 mars 2020. Étant donné que la compétence de votre cour est établie avec rigueur, Permettez-moi dès à présent de débobiner devant vous l'effroyable tapisserie de crimes commis sous le commandement du colonel Elmore. Car il ne s'agissait pas de simples violations aux lois et coutumes de la guerre, mais d'une entreprise criminelle systématique de déshumanisation. Celle-ci infère, au sens de l'article 61, paragraphe 5 du statut de Rome, des motifs substantiels de croire que les forces armées tirvaniennes, sous le commandement du suspect, ont commis de crimes de guerre. Ainsi, dans les temps qui nous est imparti, je vous démontrerai l'existence des crimes de guerre commis par les forces armées tirvaniennes. Puis ma consoeur établira la responsabilité écrasante du suspect en tant que chef militaire. Honorable juge, pour qualifier ces exactions de crimes de guerre, le procureur a adopté le raisonnement binaire de la jurisprudence internationale constante qui établit que les crimes de guerre conjuguent à la fois éléments contextuels et éléments spécifiques. En ce sens, Monsieur le Président, le contexte juridique foulé aux pieds permet de qualifier ces exactions de crimes de guerre sur base de 3 piliers. Premièrement, l'existence d'un conflit armé non international. Deuxièmement, la connaissance qu'a l'auteur de ce conflit. Et troisièmement, le nexus ou le lien entre le conflit et les actes criminels. Honorable Président, il y eut réellement un cani anti-irvanien. En effet, au sens du paragraphe 70 de l'arrêt étadique du TPY du 15 juillet 1999, il consiste en un recours à la force prolongée entre les autorités gouvernementales et des groupes armés organisés. Ce type de conflit requiert, au sens du paragraphe 357 de l'affaire Semanza du 15 mai 2003 du TPIR, 2 critères cumulatifs: l'organisation des parties et l'intensité des hostilités. Parlant de l'organisation des parties, le paragraphe 16 de l'exposé factuel, en cohérence totale avec la jurisprudence internationale constante, permet de conclure que l'AELIS était un groupe armé organisé. Ce groupe, avec une discipline de fer et une structure hiérarchique, était dirigé par M. Maël Trivan, avait des commandants de zone, comptait 1200 membres, avait la capacité de se procurer des équipements militaires et avait un quartier général. Concernant l'intensité des hostilités maintenant, l'exposé factuel démontre que les combats ayant fait plus de 6 ans avaient engagé l'armée tirvanienne sans que cette dernière ne parvienne à pacifier la situation. Ce conflit avait engendré des redoutables attaques dans toute la province de Kanto. Des drones armés équipés de munitions explosives à fragmentation et des armes autonomes furent employés de manière indiscriminée. C'était donc résolument un cani dont les FAT ne pouvaient ignorer l'existence. En effet, le recours à la violence entre elles et la hélice le démontre clairement au sens du jugement Bemba de la CPI du 21 mars 2016 au paragraphe 667. Et en adhérant au raisonnement du TPR...
Excusez-moi de vous interrompre, mais qu'est-ce qui prouve dans ce que vous avez dit qu'il s'agit d'un CANI et pas d'un KI?
Merci beaucoup, Monsieur le Président, pour cette question. Ce qui prouve qu'il s'agit d'un CANI et non d'un KI, c'est d'abord, premièrement, les acteurs du conflit qui sont aux prises. Parce qu'un KI exige, premièrement, 2 États et, dans certaines situations, un groupe armé qui agit au nom de l'État. Donc, dans le cas d'espèce, il s'agissait bien d'un groupe armé et d'un État qui, au sens de l'article 1 du protocole additionnel de la Convention de Genève, remplit les conditions pour qu'on puisse l'appeler CANI. Comme je venais de le dire, en adhérant au raisonnement constant du TPIR dans l'arrêt Kunarak, du 12 juin 2002 au paragraphe 58, ce conflit avait servi de levier au crime. En effet, il leur avait fourni à la fois capacité opérationnelle et motivation idéologique. Honorable juge, étant donné que les éléments contextuels sont réunis, passons maintenant de la théorie à l'innommable, c'est-à-dire aux éléments spécifiques.
Si vous permettez, Maître, je voudrais juste revenir sur la question de la qualification du conflit. Alors, vous avez donné tout à l'heure une référence. Vous avez semblé parler du protocole additionnel 1. Je voudrais juste que vous confirmiez qu'il s'agit bien de la référence que vous avez donnée. Et ensuite, j'aimerais vous entendre sur la question d'internationalisation possible de ce conflit. Pourquoi vous estimez qu'elle n'est pas de nature à être internationalisée? Merci.
Merci, monsieur le juge, pour cette question. Le procureur reconnaît qu'il a certainement fait un lapsus. Le procureur voulait parler du protocole additionnel 2. Par rapport à la nature internationalisée du conflit, le procureur n'a pas retenu cette qualification parce que le procureur a estimé que ni le contrôle global établi par la Cour internationale de justice dans l'affaire Bosnie-Herzégovine contre Serbie-Monténégro, également reprise par les TPY.
Contrôle global, vous avez dit?
Le contrôle global n'est pas établi dans le cas d'espèce.
Établi par la Cour internationale de justice.
Elle est établie premièrement par les TPY dans la RITADIC, mais elle a été reconnue comme seuil d'internationalisation d'un conflit par la Cour internationale de justice dans l'affaire de Bosnie-Herzégovine contre la Serbie-Monténégro. En effet, les FAT, dans une ambition ravageuse de semer la terreur, se sont rendus coupables de meurtres, d'attaques contre des civils et des biens protégés, du viol et d'esclavage sexuel. Crimes de guerre punis aux articles 8, paragraphe 2, littéra C et littéra E du statut de Rome. D'abord, le meurtre. Au sens de l'article 8 de CI du statut de Rome, il consiste dans le fait de tuer des personnes hors de combat. En l'espèce, à Solvia, entre le 5 et le 15 mars 2020, 57 exécutions sommaires, 57 violations du droit sacré à la vie, tel que consacré par l'article 6 du Pacte international relatif aux droits civils et politiques. Un tel acte choque la conscience universelle. Les victimes étaient des civils.
Monsieur le procureur, d'où tirez-vous ce chiffre de 57 exécutions?
Merci beaucoup, Madame la juge, pour cette question. Nous tirons ce chiffre de 57 exécutions sommaires du rapport d'iPeace établi dans le paragraphe 45 du rapport factuel.
Et est-ce suffisant pour établir la mort de ces 57 personnes?
Madame, vous pouvez répéter votre question, je n'ai pas bien saisi.
Je voudrais savoir quelle force probatoire vous donnez au rapport d'iPeace ici.
Ah, ok. Merci beaucoup, Madame la juge, pour cette question. En effet, nous soutenons que les preuves venant du rapport conjoint d'iPeace ont une grande valeur probante. Pour le démontrer, nous revenons à la jurisprudence de la Cour pénale internationale dans l'affaire Katanga Ngunjolo, paragraphe 20, qui établit que la valeur probante doit s'étudier au regard de la fiabilité de l'élément de preuve et de la mesure dans laquelle cette preuve est susceptible d'influer sur la détermination d'un point donné dans l'affaire. Dans le cas d'espèce, les éléments de preuve fournis par les rapports d'iPeace sont fiables premièrement et elles sont susceptibles de déterminer un point donné dans l'affaire. Et aussi, cette même jurisprudence a reconnu que votre cour doit admettre ce genre de preuves au paragraphe 89. D'abord, excusez-moi, les auteurs en avaient la connaissance, mais les ont intentionnellement tués. Puis, les attaques contre des civils et des biens protégés au sens de l'article 8 de EI et 8 de EIV du statut de Rome. Elles consistent respectivement à diriger intentionnellement des attaques contre des civils ou contre des biens protégés. Et au sens de la décision Katanga Ngunjolo de la CP du 30 septembre 2008 au paragraphe 270, c'est l'acte intentionnel de violence qui compte, peu importe les résultats. Ainsi, pour la première, dans la nuit du 4 au 5...
Cher maître, excusez-moi de vous interrompre. Est-ce que l'intentionnalité ici a été prouvée? Est-ce que vous avez des éléments de preuve qui vont dans le sens de cette intention?
Merci beaucoup. Merci beaucoup, Madame la juge, pour cette question. Nous avons des éléments de preuve qui vont dans le sens de cette question. Étant donné que le rapport factuel nous démontre que l'opération Tassouma avait été menée avec pour but de semer la terreur dans les chefs de la population civile. Ceci démontre l'intention et au-delà même aussi la connaissance au sens de l'article 30 du statut de Rome. Les civils se trouvèrent privés du droit à la sécurité consacré par l'article 9 du Pacte international relatif aux droits civils et politiques. Par ailleurs, le procureur soutient que le cas du meurtre établi rigoureusement si haut doit ménager votre cour à retenir cette incrimination, car les exécutions sommaires constituent des attaques au sens de l'article...
Pardon, mais vous avez invoqué le droit à la sécurité au sein du pacte. Est-ce que, du coup, il s'agit d'engager la responsabilité d'un État qui est soumis aux obligations du pacte, ou bien est-ce qu'il s'agit d'engager la responsabilité pénale individuelle de personnes lorsqu'on parle de ce droit à la sécurité? Et est-ce que vous avez de la jurisprudence qui vient au support de votre argumentation?
Merci beaucoup, Monsieur le Président, pour cette question. Il ne s'agit pas d'engager la responsabilité de l'État, mais il s'agit plutôt de démontrer le droit fondamental qui a été violé par rapport à l'attaque lancée contre la population civile. Par ailleurs, le cas de meurtre établi rigoureusement si haut doit ménager votre cour à retenir cette incrimination au sens de l'article 49, paragraphe 1 du protocole additionnel 1 aux conventions de Genève. Parce qu'une attaque se définit comme étant un acte de violence. Ensuite, le viol, au sens de l'article 8 de VI1 du statut de Rome. Il consiste en la prise de possession de corps par des actes de pénétration, sans consentement. En l'espèce, les forces armées tirvaniennes violèrent 77 femmes, soit par la force, soit en faveur de l'environnement coercitif qui régnait à Solvia entre le 5 et le 15 mars 2020, uniquement dans le but de semer la terreur et de dominer. Enfin, l'esclavage sexuel au sens de l'article 8 de EVI2 du statut de Rome. Il consiste en l'exercice de l'un quelconque ou de la totalité des pouvoirs découlant de droits de propriété sur une ou plusieurs personnes en les imposant une privation de liberté et les contraignant à accomplir des actes de nature sexuelle. Et comme l'ont si bien établi les chambres africaines extraordinaires dans le jugement Hissène Habré au paragraphe 1536, la réduction à l'état d'esclavage sexuel est l'essence même de ce crime. En l'espèce, honorable juge, les femmes violées par les FAT étaient premièrement internées dans des centres improvisés. Un tel acte est insupportable. Honorable juge, tous les éléments essentiels de ces incriminations sont réunis en l'espèce. L'équivoque a donc été levé, l'élément psychologique établi. Les FAT avaient la connaissance et l'intention requises à l'article 30 du statut de Rome pour commettre ces exactions.
Alors, monsieur le procureur, vous avez évoqué une disposition du statut de Rome. Est-ce qu'elle s'applique à un conflit, dans les situations de conflit armé non international?
Merci beaucoup, monsieur le juge, pour cette question. L'article 8 du statut de Rome établit respectivement les crimes de guerre qui peuvent être perpétrés dans le cadre d'un conflit armé international et dans le cadre d'un conflit armé non international. Les dispositions que le procureur a soulevées s'appliquent dans le cadre d'un conflit armé non international, parce qu'il s'agit de l'article 8, littéra E. Avec votre autorisation, monsieur le président, je passerai dès à présent la parole à ma consoeur qui va vous démontrer la responsabilité écrasante du suspect.
Très bien, et je demanderai à la salle d'être silencieuse, s'il vous plaît, pendant que les plaideurs plaident.
Honorable juge, derrière chacun de ces crimes, il y a une abstention coupable, celle du colonel Drax Elmore. Sa responsabilité, Monsieur le Président, est celle prévue à l'article 28A du statut de Rome, soit celle d'un chef militaire ayant manqué à ses devoirs de diligence lors de l'opération Tassouma. Ainsi, Monsieur le Président, notre propos comportera une ossature bipartite. Dans un premier temps, Monsieur le Président, nous parlerons de l'actus reus, rea. Et dans la seconde partie...
Terminez votre phrase et je vous poserai la question ensuite.
Dans la seconde partie, nous parlerons de mens rea.
Madame le procureur, vous parlez d'abstention coupable, de manquement à l'obligation de diligence. Or, au paragraphe 45 de l'exposé des faits, on nous dit qu'à Solvia et dans d'autres localités, les hommes du sous-lieutenant Capot, sous les ordres directs du colonel Helmut, prennent d'assaut les centres médicaux, les écoles et les stations radio. Et je voulais savoir si, par rapport à ces faits, vous restiez aussi dans la responsabilité pour une abstention.
Merci beaucoup, Madame la juge, pour la question. Par rapport à ça, nous restons dans la responsabilité au nom et pour le compte du chef militaire qui est le colonel Drax-Elmore. Sans plus tarder, Madame la Présidente, nous allons passer à l'élément intentionnel, l'actus reus, rea. Monsieur le Président, le suspect est un chef militaire qui exerçait un commandement et un contrôle effectif sur les FAT. En accord total avec la jurisprudence constante, la Chambre de première instance 2, dans le jugement Bemba, paragraphe 181, estimant que le contrôle effectif exige que les chefs militaires aient la capacité matérielle d'empêcher ou de réprimer l'exécution de crimes ou d'en référer aux autorités compétentes. Monsieur le Président, honorables membres de la Cour, parlons maintenant de mens rea. Le suspect savait, ou en raison de circonstances, aurait dû savoir, au sens de l'article 28 AI, que ses subordonnés commettaient des crimes de guerre. Il avait donc la connaissance. Le colonel Elmore savait, il avait la connaissance. Et pour démontrer cette connaissance, Monsieur le Président, en complet accord avec le jugement Bemba de la Chambre de première instance 2 de la CPI au paragraphe 193, le suspect était personnellement informé que ses troupes étaient impliquées dans ces atrocités criminelles, en atteste la correspondance d'iPeace du 18 avril 2020. Ou encore, de manière prévisible.
Permettez,
oui, Monsieur le
par
Président.
rapport à la connaissance, doit-elle intervenir avant le fait ou après le fait? S'agit-il d'une connaissance ante factum ou post factum?
Monsieur le Président, si vous permettez, vous pouvez réexpliquer la question pour que nous puissions vous fournir les éléments de réponse.
Je ne vais pas réexpliquer, je vais reposer ma question.
Ok.
S'agit-il d'une connaissance avant les faits ou après les faits? S'agit-il d'une connaissance ante factum ou post factum? Est-ce que cela est requis dans la disposition que vous avez alléguée?
Monsieur le Président, ici, il s'agit d'une connaissance avant et après les faits.
Mais juridiquement, quel est le critère?
De la connaissance avant le fait et après le fait?
Est-ce qu'il faut qu'elle soit établie avant ou après les faits, dans la jurisprudence que vous évoquez, dans les textes que vous évoquez?
Monsieur le Président, il faudrait qu'elle soit établie avant les faits normalement, pour parler de la responsabilité. Comme ça, ça pourrait lui permettre d'interdire ou de réprimer les actes. Pour revenir sur ce que nous étions en train de dire, Monsieur le Président, ici, nous avons l'attestation de la correspondance d'iPeace du 18 avril 2020, où, de manière prévisible, le suspect a même félicité ses troupes pour les crimes qu'il avait commis. Aussi le caractère notoire des crimes, la position qu'il occupait et les moyens de communication assurant un contrôle effectif sur ces opérations démontrent sa connaissance effective au sens du jugement précité, le jugement Bemba au paragraphe 717. Monsieur le Président, le suspect savait, mais n'a pas pris toutes les mesures nécessaires et raisonnables qui étaient à son pouvoir pour empêcher ou réprimer ces infractions ou pour déférer ceci aux autorités compétentes aux fins d'enquête et des poursuites.
Maître, vous vous appuyez sur une série de jurisprudences de la Cour pénale internationale et de juridiction pénale de manière générale. Est-ce que notre Cour serait autorisée à se départir de cette jurisprudence et à adopter un autre critère? Est-ce que juridiquement c'est possible que nous décidions de mettre à l'écart la jurisprudence de la Cour pénale internationale pour appliquer d'autres critères jurisprudentiels?
Merci beaucoup, Monsieur le Président. Nous allons revenir sur la question. Entre-temps, nous allons continuer avec la plaidoirie.
Excusez, Madame la procureure, je vous ai entendu dire que le colonel Drax a manqué à prendre des mesures nécessaires pour réprimer les actes qui lui auraient été communiqués. Alors, voudriez-vous éclairer la Cour par rapport à ce manquement, par rapport à la loi d'amnistie qu'avait adoptée l'État de Trivanien? Merci.
Merci beaucoup, Monsieur le Président. Alors, pour revenir à la question sur la loi d'amnistie adoptée par l'État du Tirvania, la loi d'amnistie voudrait à ce que le responsable, les chefs militaires soient pénalement responsables. Mais maintenant, nous avons l'article 30, si je ne me trompe pas, du statut de Rome, qui pose l'impertinence de cette loi d'amnistie pour des crimes internationaux. Monsieur le Président, ceci a pour conséquence que les crimes n'ont pas été empêchés et ont été commis dans les circonstances où ils l'ont été. Le suspect est allé encore plus loin. Il n'a pas veillé à ce que les cybercapacités utilisées par le troupe, exceptionnellement l'arme autonome, respectent le DIH. Pour cette commission, il doit donc engager sa responsabilité et être sanctionné, même si la décision ultime de commettre le crime a été prise par une arme autonome, Monsieur le Président. Honorable juge, comme l'a affirmé Louis Joannet, l'impunité est à la fois source et conséquence du silence et de l'oubli. Derrière toutes ces communautés réduites en cendres au quintos, 57 morts et les 77 femmes réduites en esclavage et violées, se dresse aujourd'hui l'écho des victimes et la conscience universelle qui s'élève contre l'oubli et disent à votre cour, plus jamais ça. Ainsi, nous demandons à votre cour qu'en plus de s'être déclarée compétente, qu'elle confirme la culpabilité du colonel Drax, au sens de l'article 28A du statut de Rome pour les crimes de guerre ayant pris la forme des meurtres, d'attaques contre les civils et les biens protégés, des viols et l'esclavage sexuel perpétrés par les FAT lors de l'opération Tassouma du 4 au 15 mars 2020. Nous avons dit, Monsieur le Président.
Très bien, merci beaucoup, Maître. Voici qui clôt le premier tour de plaidoirie présenté par le bureau du procureur. J'appelle maintenant à la barre les représentants, le premier représentant de la défense pour une durée de 25 minutes également. Maître, vous avez la parole.
Monsieur le Président du séant, honorable juge, là où croient les périls, croient aussi ceux qui sauvent. Votre prestigieuse cour est aujourd'hui sollicitée sur la question complexe relative au développement et à l'émergence de nouvelles technologies dans ses rapports avec la responsabilité pénale du supérieur hiérarchique. L'accusation tient le colonel Drax Elmore responsable notamment parce qu'il n'aurait pas veillé à ce que les cyberattaques utilisées par ces groupes, en l'occurrence l'arme autonome, respectent le droit international humanitaire, tout en ne reconnaissant pas clairement dans son mémoire que des décisions ultimes de commettre ces crimes a été prise par une arme autonome plutôt que par un opérateur humain en temps réel. Mais qu'il me soit permis, avant d'aborder les grandes lignes de ma plaidoirie, de revenir sur certaines choses qui viennent d'être dites par le bureau du procureur. Il est écrit dans leur mémoire au paragraphe 50 que votre cour doit établir la culpabilité de M. Drax Elmore en tenant compte du standard de motif substantiel de croire. Je rappelle que l'étape qu'a atteint cette procédure n'est plus adaptée à ces standards, parce qu'il s'agit ici d'établir la culpabilité de M. Drax Elmore. Et pour cela, au terme de l'article 66 du statut de Rome de la Cour pénale internationale, toute personne est présumée innocente jusqu'à ce que sa culpabilité ait été établie devant la Cour conformément au droit applicable. Il incombe au procureur de prouver la culpabilité de l'accusé, et pour condamner l'accusé, la Cour, j'attire l'attention de la Cour, doit être convaincue que sa culpabilité est établie au-delà de tout doute raisonnable. Et pour s'en convaincre, la situation au Kenya du 31 mars 2010, à partir de ces paragraphes 28 à 35, précise les degrés et les standards de preuve à statuer devant vous. Il s'agit notamment de la première norme qui figure à l'article 58 du statut de la Cour pénale internationale, nommé le motif raisonnable de croire. Et la deuxième norme est le motif substantiel de croire. Mais pour établir la culpabilité, il faudrait qu'il n'y ait aucun doute, donc au-delà de tout doute raisonnable, contenu à l'article 66-3 du statut de la Cour pénale.
Maître, je me permets de vous interrompre. Alors, quelle est selon vous la différence entre le standard de preuve que vous évoquez actuellement et qui concerne la question de la culpabilité? Donc vous avez dit le standard c'est au-delà de tout doute raisonnable. Quelle est la différence entre ce standard et le standard exigé à l'article 28 pour procéder ou conduire le test de connaissance dans le cadre de la responsabilité du supérieur hiérarchique ou militaire?
Merci, monsieur le membre de la Cour de la question. Il faudrait préciser que les standards de preuve dans le statut de la Cour pénale internationale ne sont contenus que dans les 3 dispositions que j'ai citées. L'article 58 pour le motif raisonnable de croire, l'article 61-7 pour le motif substantiel de croire et l'article 66. L'article 28 ici ne parle pas d'un standard, mais plutôt du titre au moyen desquels une personne peut engager sa responsabilité. Et partant, les critères de connaissance est contenu parmi les 3 conditions cumulatives que le procureur doit établir pour que la connaissance ou une qualité de supérieur hiérarchique ou de chef militaire soit attribuée à un accusé. Telle est notre réponse.
Le procureur nous parle de l'article 28 et il nous dit, le bureau du procureur nous dit qu'il y a des raisons ou des motifs raisonnables de croire, ou pardon, que l'accusé avait des motifs raisonnables de croire que des crimes étaient commis ou seraient en train d'être commis. Donc, est-ce que ce n'est pas 2 registres différents?
Exactement. À cette étape-là, le procureur avait raison, mais à moitié, parce qu'il a été dit qu'il faudrait plaider sur la responsabilité. Il ne faut pas seulement s'arrêter sur l'établissement des charges, encore faut-il prouver la responsabilité. Or, la question de la responsabilité est contenue à l'article 66-3 du statut de Rome de la Cour pénale internationale. Monsieur le Président, honorable membre de la Cour, la défense souligne que la 3e norme, à savoir au-delà de tout doute raisonnable, a été interprétée par la Cour pénale internationale. Dans l'affaire du procureur contre Thomas Lubanga, dû au jugement du 5 mars 2012, la Cour a précisé à chaque fois qu'elle analysait un élément de preuve, il faudrait que ces derniers soient établis avec certitude. Cette norme de preuve requiert une analyse minutieuse de chaque élément de preuve parce que si le doute s'avère constructif et résiste à l'analyse de la preuve, sa substance découche à l'acquittement même de l'accusé. Monsieur le Président, honorables membres de la Cour, qu'il me soit permis ici maintenant à évaluer chacun des éléments de preuve brandis par le bureau du procureur. Il s'agit notamment des rapports des ONG, notamment l'IPeace, et des rapports des hauts représentants des Nations Unies. Quelle est donc la valeur probante de ces deux instruments brandis par le bureau du procureur? Les rapports des ONG et les rapports de l'ONU sont de preuves indirectes, conformément à la règle 76 et 77 du règlement de procédure et de preuve. Dans l'affaire Bemba du 15 juin 2009, la Chambre préliminaire 2 a précisé au paragraphe 51, ce qui suit, que la valeur probante de ces éléments de preuve indirects est de moindre valeur, c'est-à-dire pour emporter la conviction de votre cour au-delà de tout doute raisonnable, il faudrait que ces preuves soient corroborées par d'autres preuves moins pertinentes et plus pertinentes que ces derniers. Si le procureur n'arrive pas à prouver au-delà de tout doute raisonnable la culpabilité de l'accusé, cela doit signifier en priorité que l'accusé reste présumé innocent sans rejeter immédiatement la faute d'une erreur d'appréciation de juge.
Une question, est-ce que le principe de la hiérarchie de la preuve s'applique en matière pénale?
Le principe de la hiérarchie de la preuve ne s'applique pas en matière pénale.
Vous voulez hiérarchiser les preuves indirectes, les preuves directes?
Je ne suis pas en train de faire un exercice d'hiérarchisation, mais de la valeur probante. C'est-à-dire ces preuves indirectes prises de façon isolée ne peuvent pas en elles-mêmes établir la conviction de votre cour. Il faudrait démontrer en connivence avec d'autres éléments de preuve plus pertinentes ou moins pertinentes encore que ces derniers pour établir la responsabilité.
Quels seraient les éléments de preuve pertinents dans ce cas-ci?
Dans ces cas-ci, les éléments de preuve pertinents qui peuvent corroborer les rapports de l'IPeace seraient notamment les témoignages.
Alors, quelle est la valeur d'un témoignage? S'agit-il d'une preuve directe ou d'une preuve indirecte?
Le témoignage est une preuve directe. Parce que le témoin, c'est celui qui a vu et qui a entendu et vécu les faits. Donc, il y a aussi tout un standard de preuve que la Cour doit exercer pour établir la validité d'un témoignage devant son instance. J'étais tantôt disant que le procureur, s'il n'arrive pas à prouver au-delà de tout doute raisonnable la culpabilité de l'accusé, cela doit signifier en priorité que l'accusé reste présumé innocent et sans rejeter immédiatement la faute d'une erreur d'appréciation des juges. Il est envisageable de considérer que le procureur a effectué un travail incomplet des preuves ou de leur appréciation ou qu'il n'a pas réussi à les exploiter devant le juge. Telle a été la position, c'est une doctrine, l'appréciation de la preuve devant la Cour pénale internationale, la thèse écrite par Jeremy Hall en 2016.
Quelle valeur, maître, devons-nous accorder à cette doctrine?
En vertu de l'article 21 du statut de la Cour pénale internationale, vous êtes appelé à appliquer principalement les statuts de Rome, les règlements de procédure et de preuves, et subsidiairement les arrêts et les jurisprudences rendus par votre juridiction et les autres juridictions, ainsi que les doctrines qui peuvent permettre à ce que vous puissiez mieux interpréter les dispositions de conventions et des traités.
Donc on n'est pas en mesure d'interpréter les dispositions au point qu'on doit consulter la doctrine.
Vous êtes habilité à mieux interpréter des dispositions, mais il arrive dans une situation où un concept, par exemple, n'a pas été défini par un traité ou une convention, et moins encore par une jurisprudence, la Cour peut se référer à une doctrine.
Vous dites l'adage curiano ituria.
Oui, la Cour connaît le droit, exactement, et il se sert de ces moyens de droit contenus à l'article 21 du statut de la Cour pénale internationale pour bien dire le droit.
L'article 21 mentionne la doctrine.
In fine, exactement.
Pardon?
In fine.
La doctrine. À l'article 21 du statut de Rome.
Je n'ai pas les statuts avec moi ici, j'aurais dû les lire. La Chambre de première instance 2, dans l'affaire du procureur contre Germain Katanga, 17 mars 2014, au paragraphe 70, a noté, je cite, « Le fait qu'une allégation ne soit, selon elle, pas prouvée au-delà de tout doute raisonnable, n'implique pas pour autant qu'elle mette en cause l'existence même du fait allégué. Cela signifie seulement qu'elle estime, au vu des standards de preuve, n'est pas disposée de suffisamment de preuves fiables pour se prononcer sur la véracité des faits ainsi allégués. » La Cour poursuit en disant, dès lors, déclarer qu'un accusé n'est pas coupable ne veut pas nécessairement dire que la Chambre constate son innocence. Une telle décision démontre simplement que les preuves présentées au soutien de la culpabilité par le procureur ne lui ont pas permis de forger sa conviction au-delà de tout doute raisonnable. Pour finir, et en vue de passer la parole à ma conseillère, je tiens à rappeler à la Cour que vous n'êtes pas appelé à trancher cette décision sur base de convictions morales. Les statuts de la Cour pénale internationale vous recommandent d'appliquer un droit qu'il a déjà établi et la jurisprudence de cette dernière est abondante pour que votre Cour ne s'écarte pas et ne croit pas aux paroles du bureau du procureur. Ainsi, je vous prie...
Maître, une dernière question sur ce que vous avez dit.
Oui.
Est-ce que le statut nous recommande de statuer en droit ou est-ce qu'on pourrait statuer ex aequo et bono?
Ici, il s'agit d'une matière pénale. Et la matière pénale exige une interprétation stricte. L'application du droit ex aequo et bono serait peut-être d'application si il faudrait recourir à un ultime cas. Donc l'ultime recours de la Cour pourrait être les ex aequo et bono, mais principalement, vous devez d'abord dire le droit de lege lata.
Monsieur le Président, honorable juge, vous venez d'entendre mon devancier qui vous a démontré que l'accusation ne dispose pas de preuves suffisantes pouvant établir la responsabilité, la commission de crime par M. Drax Elmore. À présent, il m'incombe d'aborder la question liée à la responsabilité de M. Drax Elmore. Monsieur le Président, la qualification de fait à l'un de crime qui relève de la compétence d'une juridiction. Merci. La qualification d'un fait en l'un de crime qui relève de la compétence matérielle d'une juridiction pénale internationale est nécessaire, mais pas suffisante à ce que la responsabilité d'un particulier puisse prospérer. Encore faut-il précisément démontrer le rôle de celui-ci dans la commission du crime, voir dans quelle mesure il a permis à l'infraction d'être ce qu'elle a été, puis apprécier d'éventuels motifs qui viendraient l'exonérer de ce qui lui est reproché. In specie et casu, l'accusation soutient au paragraphe 54 de son réquisitoire que M. Drax Elmore doit engager sa responsabilité en qualité de chef militaire en vertu de l'article 28.a du statut de la Cour pénale internationale. Avant toute analyse, la défense trouve impérieux de qualifier un point que l'accusation confond délibérément. M. Drax Elmore n'était pas à la tête des forces armées turvaniennes, non. Mais il était à la tête de l'opération Tassouma. Parce que les forces armées turvaniennes n'arrivaient pas à contenir l'AELIS, qui était un groupe armé organisé. C'est un peu comme si je pourrais prendre un cas similaire, les Ouazanléno en République démocratique du Congo, qui soutiennent les forces armées congolaises contre le M23, qui est un groupe armé organisé. Monsieur le Président, l'article 28.a du statut de Rome dispose que, je cite, un chef militaire ou une personne, vu qu'il me reste peu de minutes, je vous dispense de la lecture de la disposition. Monsieur le Président, honorables membres de la Cour, la Cour pénale internationale a eu à interpréter l'article 28.a du statut de Rome en ces termes. Le suspect doit exercer un commandement et lorsque la Cour a interprété cette disposition dans l'affaire Le procureur contre Jean-Pierre Bemba du 15 juin 2019 au paragraphe 407, la Cour a établi 5 critères cumulatifs que doivent être réunis pour que l'accusé soit retenu coupable au sens de l'article 28.a.
Le premier critère est que le suspect doit être un chef militaire ou une personne faisant effectivement fonction d'un chef militaire. Le deuxième critère est que le suspect doit exercer un commandement et un contrôle effectif sur le subordonné. Troisièmement, le crime commis par les forces résultant du fait que le supérieur n'a pas exercé sur celle-ci le contrôle qui convenait. Quatrièmement, le suspect savait ou en raison de circonstances aurait dû savoir que les forces commettaient ou allaient commettre ces crimes. Et enfin, le suspect n'avait pas pris les mesures nécessaires et raisonnables qui étaient en son pouvoir pour empêcher ou réprimer l'exécution de ces crimes ou pour en référer aux autorités compétentes au fond d'enquête des poursuites. Fin de citation. La défense tient à préciser que ces critères sont cumulatifs. À défaut d'un seul, la responsabilité pénale au sens de l'article 28A ne saurait être retenue. Pour s'en convaincre, le cas de M. Bemba est pertinent dans le cas d'espèce parce que la Chambre d'appel de la Cour pénale internationale, dans l'affaire le procureur contre Jean-Pierre Bemba, aurait rendu le 8 juin 2018 au paragraphe 194 a déclaré que, je cite, « La Chambre d'appel juge à la majorité de ses membres étant en désaccord que les erreurs énumérées plus haut ont sérieusement entaché la conclusion de la Chambre de première instance selon laquelle Bemba n'aurait pas pris toutes les mesures nécessaires et raisonnables en réaction de crimes commis par le MLC en République centrafricaine. » La Chambre poursuit en disant « Partant, un des éléments de la responsabilité du supérieur hiérarchique visé à l'article 28A du statut de Rome, n'ayant pas été dûment établi, Bemba ne saurait être retenu responsable au sens de cet article de crimes commis par les troupes du MLC au cours de l'opération de 2002 en 2003 en République centrafricaine.
Concernant l'affaire Bemba, lequel des critères faisait défaut?
La Cour a dit que Bemba, la Chambre de première instance avait tort de dire que M. Bemba n'avait pas pris les mesures nécessaires pour empêcher que les troupes qui étaient déployées en République centrafricaine avaient commis de crimes. En fait, la Cour avait dit qu'au moment où ces troupes-là étaient en République centrafricaine, Bemba n'exerçait plus un contrôle effectif sur eux. Et de ces faits, il ne pouvait plus prendre de mesures nécessaires pouvant empêcher ou en référer ces crimes aux autorités compétentes pour ainsi que ces subordonnés ne puissent pas commettre ces crimes.
En l'espèce, quel est le ou les critères qui vous semblent faire défaut?
Exactement. En l'espèce, la défense retient trois critères qui font défaut. Il s'agit premièrement du contrôle effectif, deuxièmement de la connaissance de crimes et enfin du manquement au devoir d'agir. S'agissant du contrôle effectif, le tribunal pénal international pour l'ex-Yougoslavie a, dans l'affaire le procureur contre Delalic du 16 novembre 1998, au paragraphe 370, établi que le statut du supérieur à lui seul ne suffit pas. Encore faut-il démontrer que celui-ci avait un contrôle effectif pouvant lui permettre d'empêcher les actes au moment où ils étaient en train de se commettre. En l'espèce, M. Drax n'avait pas le contrôle effectif au cours des opérations militaires produites dans la ville de Kavou. Il ressort de la trame factuelle au paragraphe 44 que les hommes de l'opération Tassouma agissaient conjointement avec les forces armées survanianes. Et M. Drax Elmore lui-même agissait sous l'autorité du ministre de la Défense, l'initiateur de l'opération Tassouma. Et toutes les actions qui ont été menées dans cette opération l'ont été conformément aux instructions du ministre de la Défense. En plus du contrôle effectif, le supérieur doit avoir eu connaissance de faits. Ah, c'est ici que se trouve le problème.
J'ai une double question, maître.
Merci.
Tout d'abord, l'ordre du ministre dégage-t-il la responsabilité du colonel ici? Ça, c'est ma première question. Et deuxièmement, ma question porte sur le paragraphe 47 de l'exposé des faits, dans lequel on explique qu'iPeace a adressé une correspondance officielle au colonel Elmore détaillant les exactions imputées à ses troupes. Et derrière, on apprend que, au lieu de mener une enquête, il y a eu des louanges qui ont été adressées à ces hommes pour leur, je cite, bravoure patriotique, assimilant les crimes commis à de légitimes représailles contre les ignominies de la hélice. Donc je voudrais que vous répondiez sur ces deux points. D'une part, la question de l'ordre du ministre, savoir si cela dégage la responsabilité du colonel, et ensuite sur la question de la connaissance, on a quand même des éléments au paragraphe 47 qui laissent entendre qu'il aurait au moins dû mener une enquête. Merci.
Merci beaucoup. S'agissant de la question de l'ordre du ministre, il faut savoir que l'opération Tassouma, lorsque elle a été lancée, le ministre voulait à ce que le colonel Drax Elmore mette fin aux exactions. Et d'ailleurs, les Tassouma s'est traduit en français comme le fait. C'était une opération d'une grande envergure. C'est que le ministre avait déjà donné des instructions au colonel comment l'opération devait se conduire. S'agissant de la connaissance.
De quelle langue ça se traduit en français par le feu?
On n'a pas parlé de la langue. S'agissant de la connaissance, encore la connaissance, la Cour pénale internationale et le Tribunal pénal international pour l'ex-Yougoslavie ont établi que la connaissance ne se présume pas. Elle doit être établie sur des éléments de preuve conjecturaux, établis par des rapports des experts. Or, ici, on nous parle d'un rapport de iPeace qui est une ONG. Et mon confrère vient de vous le dire, que les rapports des ONG sont des éléments de preuve indirects qui présentent une force probante inférieure. S'agissant de la connaissance, le Tribunal pénal international pour l'ex-Yougoslavie et la Cour pénale internationale
le rapport de l'ONG a néanmoins et des révélations médiatiques, parce qu'il n'y a pas que le rapport de l'ONG, mais cela a quand même conduit le Conseil de sécurité à se réunir, et donc le Conseil de sécurité a jugé que c'était un élément qui était suffisamment intéressant pour qualifier la situation au Tirbania de menace contre la paix et la sécurité internationale. Est-ce que sans qu'il y ait directement un établissement des faits du simple fait du rapport de l'ONG, est-ce que cela ne devait pas conduire à une procédure d'enquête qui semble faire défaut ici?
Merci beaucoup. Quelqu'un a dit « la presse n'a jamais été objective ». Et donc, l'on ne peut pas se fonder justement sur de soupçons ou encore de faits établis par la presse. Encore faut-il mener des enquêtes rigoureuses. Parce que, je vous rappelle, les enjeux d'un procès pénal sont d'une extrême gravité pour l'accusé, qui risque sa vie, sa dignité et son intégrité. Donc, il serait hasardé et surtout contraire aux droits fondamentaux de l'accusé de se baser uniquement sur de simples rapports des ONG pour établir la culpabilité de ces derniers. Par ces motifs, Monsieur le Président, honorable membre de la Cour, parce que je pense que j'ai presque fini mes minutes, la défense prie à la Cour de dire et de juger que le crime de guerre ne saurait être établi, d'autant plus que les éléments de preuve présentés par l'accusation sont insuffisants et que la responsabilité de M. Drax Elmore, au titre de l'article 28, point A du statut, ne saurait être retenu car les critères dégagés par la Cour ne sont pas remplis à l'espèce. Merci.
Merci beaucoup, Maître, pour vos observations, donc, qui clôturent le premier tour d'observation orale du bureau du procureur de la Défense. Je vais maintenant passer la parole à la demande, qui va pouvoir donc s'exprimer pour une durée de 5 minutes, durant laquelle il n'y aura pas de questions posées. Maître, vous avez la parole.
Merci beaucoup, Monsieur le Président, pour la parole. Avant de faire ma réplique, je tenais d'abord à revenir sur la question posée par le juge sur la responsabilité au sens de l'article 28A du statut de Rome, qui serait soit ante factum ou soit après la commission des faits. Au sens de l'article 28AI du statut de Rome, on rappelle qu'un chef militaire doit soit savoir ou doit soit, en raison des circonstances, savoir que des crimes sont commis. Et donc, l'article 28AI2I demande qu'il puisse prendre des mesures nécessaires et raisonnables. C'est pour dire qu'en l'espèce, cette responsabilité peut soit s'appliquer avant Et quand ça s'applique avant, il doit empêcher. Si ça s'applique après, il doit réprimer, soit déférer aux autorités compétentes. Ensuite, je voudrais aussi répondre à la question sur la loi d'amnistie. En effet, la compétence de la Cour a été établie avec rigueur. Mais comme le juge souhaite revenir sur cette question, nous voulons souligner que l'amnistie doit être inopérante, dans la mesure où il ressort de la pratique des États, mais aussi des résolutions du Conseil de sécurité, que pour des crimes de guerre et des crimes internationaux qui choquent la conscience universelle, l'amnistie ne doit pas être opérante. Et par rapport à la question de la jurisprudence, en quoi est-ce que la jurisprudence est pertinente devant votre cour, nous revenons à l'article 38 du statut de la CIJ qui pose la jurisprudence comme étant une source de droit et nous rappelons à votre cour qu'au sens de l'article 26 de la Convention de Vienne sur le droit des traités, vous êtes censé l'appliquer car vous êtes partie à la Charte des Nations Unies. Alors, par rapport aux exceptions soulevées par la défense, le procureur souhaite d'abord rappeler qu'il n'a pas dit ce que la défense a dit sur l'arme autonome. Le procureur a bien dit que tout acte ou toute omission de nature à constituer une participation criminelle doit être sanctionnée, même si la décision ultime de commettre le crime a été prise par l'arme autonome. Deuxièmement, par rapport aux argumentaires de la défense sur la condamnation au-delà de tout doute raisonnable. Le procureur tient à rappeler qu'on doit respecter le principe des doubles juridictions qui est posé tant dans les juridictions internes que dans les juridictions internationales. En l'espèce, le procureur rappelle que cette chambre, comme elle vient de se saisir pour la première fois de cette situation, elle fait office de chambre préliminaire, comme le ferait devant la Cour pénale internationale. Et à ce stade de la procédure, on doit dégager les motifs substantiels de croire. Et comme cela est admis dans la jurisprudence Calixte Maroucha, au niveau de l'émission des mandats d'arrêt, il faut que les éléments de preuve suscitent des motifs raisonnables de croire. Au niveau de la chambre préliminaire, des motifs substantiels, et au niveau de la chambre de première instance, au-delà de tout doute raisonnable. Par rapport aux preuves, Monsieur le Président, les preuves sur lesquelles nous nous fondons, bien qu'étant des preuves indirectes, sont admises par devers votre cour. Parce que d'abord, elles sont pertinentes, et que la jurisprudence que nous avons citée tout à l'heure, je voulais dire, le démontre au paragraphe 89 comme étant admise par devers votre cour. Pour les questions relatives à la responsabilité au niveau de la réplique, je laisserai dès à présent ma consoeur la parole.
Monsieur le Président, les termes chef militaire renvoient à une personne qui est officiellement nommée pour exercer les fonctions de commandement militaire conformément au paragraphe 176 de l'affaire Bemba de 2016. Alors, les chefs militaires, donc le colonel Drax-Elmore et ses troupes, font généralement partie des forces armées de l'État dans lesquelles ils vivent. Ils sont premièrement nommés conformément aux droits, aux procédures et aux pratiques internes de cet État. On les appelle les chefs de jure. Alors, Monsieur le Président, le colonel Elmore ainsi que ses troupes le colonel Elmore engage sa responsabilité au sens de l'article 38-39 sur l'élément matériel et les paragraphes 46 et 47 qui démontrent l'élément intentionnel. Nous avons dit.
Merci beaucoup, Maître. Je me tourne maintenant vers la défense qui peut exercer donc son droit de duplique pendant 5 minutes également. Vous avez la parole.
Merci beaucoup, Monsieur le Président. La duplique de la défense racontera 2 points. Premièrement, le point lié au motif substantiel de croire que l'accusation continue de soutenir. En effet, le standard de preuve que la Cour pénale a prévu est spécifique à chaque situation. Lorsqu'il s'agit de l'ouverture des enquêtes, la Cour parle de base raisonnable. Lorsqu'il s'agit de confirmation de charge, la Cour parle de motif substantiel de croire. Et lorsqu'il s'agit d'établir la culpabilité de la personne, il faut que la conviction de la Cour se fonde sur des éléments de preuve au-delà de tout doute raisonnable. Je ne pense pas que vous êtes là pour confirmer de charges. Non. Et d'ailleurs, la question de la compétence a été déjà close. Vous êtes là pour établir la culpabilité de messieurs Drax et Elmore. Et sur ça, vous devez vous fonder sur l'article 66-3 du statut de Rome qui prévoit la norme d'au-delà de tout doute raisonnable et non sur l'article 61 qui prévoit la norme de motif substantiel de croire qui concerne la confirmation de charges. S'agissant de la question liée aux armes, il ressort de la trame factuelle que les attaques du 4 mars et du 5 mars résultent d'un dysfonctionnement technique. Il ne s'agit nullement d'actes prémédités. Comment est-ce qu'on peut reprocher à une personne de ne pas avoir anticipé une erreur qui échappe à une maîtrise humaine? C'est déraisonnable. C'est déraisonnable. Comment est-ce que le colonel Drax Elmore aurait su que ses subordonnés allaient commettre une erreur pour pouvoir empêcher que ceux-ci ne commettent pas leurs erreurs? Monsieur le Président, honorables membres de la Cour, comme mon confrère venait de vous le dire, les questions liées à la responsabilité pénale sont d'une interprétation stricte. Et d'ailleurs, la Cour pénale internationale a jugé dans l'affaire le procureur contre Germain Katanga que les corollaires de ces principes de l'interprétation stricte est une double pro. Nullement les doutes ne peuvent profiter à l'accusation. Les doutes profitent toujours à l'accusé parce que c'est à l'accusation qu'incombe la charge de la preuve, statuer sur l'acquittement ou la culpabilité d'une personne. Et comme je venais de vous le dire, que les enjeux d'un procès pénal sont d'une extrême gravité pour l'accusé qui risque sa vie, sa dignité et son intégrité physique. Et il serait donc hasardé de se fonder sur des preuves ou encore sur des allégations de l'accusation non vérifiées pour vous statuer sur la culpabilité de M. Drax Elmore. En considérant ce qui vient d'être dit, les conseils de la défense réitère son dispositif. Nous avons dit.
Très bien, merci beaucoup maître. Voici qui clôt cette audience et cette finale francophone de cette 10e édition du concours des Grands Lacs. Avant que la Cour se retire pour délibérer, je souhaite, je pense, en notre nom à tous, vous féliciter chaleureusement pour la qualité de votre travail, la grande qualité de votre travail et des plaidoiries qu'on a entendues aujourd'hui. Je pense pouvoir dire en notre nom qu'on a pris beaucoup de plaisir à vous écouter, à évaluer, à vous poser des questions pour vous pousser peut-être parfois dans vos retranchements. Bravo à vous quatre et à toutes les équipes francophones et anglophones du concours. Et puis à tout à l'heure pour les résultats. On peut applaudir les plaideurs et les plaideuses.
Je me nomme Safika Doukourozi, je suis étudiante à l'université de Goma en première année de master. Je suis ici à Kigali avec mon coéquipier qui se nomme Chipamba Ntikala Josué. Il est aussi étudiant à l'université de Goma en deuxième année de master droit public interne. Nous sommes accompagnés de notre coach qui se nomme Franck Choukuru. Il est assistant à la faculté de droit de l'université de Goma. Je suis heureuse et reconnaissante. Je ne m'attendais pas à revenir avec le prix de la meilleure plaideuse. D'ailleurs, je pensais qu'on ne donnait que le prix du meilleur plaideur et je pensais que c'était tous les sexes confondus. Je l'ai appris sur place et j'étais très contente. Alors, remporter le prix de la deuxième place, c'est aussi une très grande expérience parce qu'avec mon coéquipier, nous avons beaucoup appris de cette édition. Et nous pensons pouvoir aider ceux qui viennent après nous, de l'université ou d'ailleurs, à pouvoir prendre à cœur ce défi qui est nôtre, ce défi de pouvoir faire respecter le droit international humanitaire, que ce soit en temps de paix, comme en temps de guerre surtout, et aussi de respecter le droit de l'environnement et toutes ces notions qu'on nous a apprises ici tout au long des formations. Sincèrement, je n'ai pas eu le cours de droit international humanitaire. J'ai eu par contre le cours de droit international public. C'est sûrement le seul cours à caractère international que j'ai eu. Et le droit international des investissements aussi. Mais pour le reste, vu que je sais qu'il y a d'autres étudiants qui sont sûrement dans la même situation que moi et qui s'intéressent au droit international humanitaire mais n'ont pas eu à choisir cette option-là, je pense qu'il serait important de pouvoir organiser plus fréquemment des séminaires en droit international humanitaire, en droit international de droits de l'homme, et des séminaires qui seront ouverts à tout le monde pour essayer de faire comprendre aux gens ce qu'est le droit international humanitaire. Une fois, dans les séances des formations qu'on nous donnait, l'un des experts avait dit qu'il conseillait aux gens de pouvoir être des conseillers juridiques des groupes armés. Je pense que je soutiens son avis. Parce que si les rebelles prenaient conscience de ce qu'est le droit international humanitaire, je crois qu'ils agiraient un peu mieux avec la vie humaine et tout ce qui pourrait nuire à l'humanité.
My name is Mukisa Joshua William and I'm from Makerere University in Uganda. For this round of the Great Lakes Moot Court competition, my partner was Mirungi Prima Elizabeth. Well, I expected this to be mainly a moot competition, but when I did arrive, I noticed that besides it being a moot competition, there was an opportunity to learn. We had conferences, trainings, we had interactions, the opportunity to network with people from diverse backgrounds, and this was a cherry on top, because just the order of the competition alone was enough for you to acquire intellect, knowledge, an understanding of this tricky subject, but then with the opportunity to interact with these experts who were there, free access between the students and professors, persons with PhDs, authors, indescribable would be the best word. But also, I think that it inspires students, the young generation. It gives them an opportunity, a space where they can interact with their mentors, people that they would otherwise only meet in books. And so I find that the expectation of it just being a competition has been far surpassed, with this being an opportunity to make new friends, interact with your inspiration, mentors, and also discover new path in life. Absolutely. the knowledge acquired here can be utilized, to arbitrate some of these armed conflicts taking place around the African continent, in the Great Lakes region, how to champion dialogue, interact with people, promote methods of transitional justice, but also bring some of the top criminals to responsibility. And I find that it is a practical activity or engagement that we had here. Not only am I having the opportunity to do what a lawyer would only have the chance at the highest level of a national court, that is at the Supreme Court or at the International Criminal Court. Here, I'm doing that, going 20 or 30 years into the future and practicing, exercising my ability to persuade the court, to exercise interpretation on complex matters of law. And I know that the knowledge acquired here will be utilized in my work throughout, the African continent, establishing the legal footprint in my region and the various areas within the Great Lakes territory. And I'm also looking at interacting with fellow youth, students, guiding them, offering them some advice, what path to pursue, and how best they can also become players in dealing with these issues that really affect us a lot on the continent. Definitely, this activity can help people get access to justice because, one, it is equipping the lawyers that are going to represent these people. But two, it is also creating awareness for these judicial mechanisms, because many people think that when crimes against humanity are committed or when war crimes are committed or things like genocide, they're all left to the government to decide what should be done. But then you get to realize that individuals too can participate. The lawyers can press charges through organized groups like NGOs. They can come together and educate people, educate governments, educate leaders about the law of armed conflict. And this then sets a standard through which people know how best they can defend themselves and the obligations that any people engaged in armed conflict would have for civilians and protected persons. So I definitely see this as something that is relevant and is going to enable people get access to justice, because here they do know now that there are crimes like genocide. It is a crime, it is an international crime. So it sheds light on the avenues available for one who is seeking justice.
Je m'appelle Reine Mahoro, je viens de l'Université Lumière de Bujumbura en 3e année baccalauréat dans la faculté de droit. Et je suis ici à Kigali avec mon coéquipier qui s'appelle Steph Darcy Iradukunda et notre coach qui s'appelle Deo Naongiriye. Alors, il est très important de parler du droit international humanitaire dans notre région des Grands Lacs parce que c'est un droit qui va de pair avec les conflits armés qui sont dans certains de nos pays. Alors, pour le cas pratique qu'on a eu à traiter, c'était vraiment un cas complexe parce qu'on devait analyser la situation en profondeur pour pouvoir déterminer les crimes qui étaient en train d'être commis dans ce pays qui était un pays fictif, mais qui pourrait effectivement être un pays de l'Afrique ou bien d'un autre continent. Et avoir à traiter ce cas nous orientait en tant que juristes sur des crimes effectivement du droit international humanitaire, mais aussi les droits humains.
My name is Joseph Isaac Masangula, a student from the University of Dar es Salaam in Tanzania. My team coach is Dr. Petro Protas, and my teammate is Gertrude Makunganya. My expectations when I was chosen to participate in the Great Lakes training in international humanitarian law and human rights were actually going to a platform where I can learn a lot of stuff. Because in the Great Lakes we have countries which are facing several problems. I can take an example of DR Congo and Burundi, where several problems are occurring every day. So my expectations were, I'm going to a platform where I will meet vibrant lawyers of tomorrow who are going to discuss solutions on how can we make efforts to ensure no any problem persists within the Great Lakes region. The message I'm going to go back with in my country, Tanzania, is Africa is one. And we Africans must ensure we unite. We unite in a manner, we need to ensure peace and stability within the Great Lakes region. Not only because Tanzania has an everlasting peace, then I should just sit and relax. No. As a youth, I have the responsibility to ensure I take a full command in order to ensure there is an everlasting peace, not only in my country, but also in the whole region of the Great Lakes.
My name is Jen Namai Wafula and I am from Kenyatta University. It's in Kenya. My teammate is Joel Ngugi Kabena and our coach is Jean Karakanyaboke. The quality of the topics discussed was a good one. There was a good choice on the topics. Indeed, I got to learn that the environment is one of the targets by the belligerents. So it's been a good choice of topics by the organizers, and I wish that they continue doing more of that, that they continue with that pace so that we get to really understand from the in-depth what this topic of law entails. Let us not leave any topic, no matter how little time we have, let us get to exhaust at least everything that might be a target of the belligerents in war. The knowledge acquired from this training is really going to be beneficial to me, to my peers, and to my community. First, to me, because next semester I'm going to undertake a unit on international humanitarian law. It is an optional unit, but I have opted to do it because I want to get to understand more what law is and the rules that govern war. To my peers, I will get to tell them about iPeace and what iPeace is doing in relation to international humanitarian law. They will get to understand from a different perspective, indeed, that there is an organization that educates persons about this topic of law. And to my community, really, when I get out there and share knowledge that I have acquired from this training, the public out there, law students, non-law students, they will get to understand the laws that govern war, and they will get to know that indeed, even if we are taking part in this armed conflict, there are rules that we must adhere to, and that will make a change to the way people conduct themselves during armed conflict. The experience I had from this training, it actually started from the memorials writing to the advisory panel and to the pleadings session. It's been a learning experience. You get to be corrected by judges, you get to be corrected by the panelists, you get a chance to ask questions from the expert during the conference and also at a personal level. So for me, it has been a learning experience and one I will always be proud of. And as at now, I can say I am living my dream, getting to one of the cities that I have always wanted to be in. So I am thankful to iPeace for this opportunity to experience something I have always wanted to experience. Yeah.
Je me nomme Anchiza Migani Ryan. Je viens de l'Université catholique de Bukavu. Je constituais une équipe avec mademoiselle Kaambutassi Deborah. Oui, notre université, notre équipe a dû remporter le prix de la meilleure équipe dans ce concours. Mais en soi, il ne s'agit pas simplement d'une victoire qui est personnelle à l'équipe, mais une victoire qui appartient à tous. En réalité, Le programme à lui seul porte déjà une formation et le concours n'a consisté que dans l'application de ce qui a été appris. Or, tous nous avions appris, certaines circonstances se sont déroulées, mais en réalité, dans ce type de compétition, dans ce type de programme, dans ce type de formation, soit on est gagnant, soit on est gagnant. Certainement, notre tâche à nous, en ayant participé à ce programme, notre tâche à nous, en ayant apprécié le programme, bien sûr aussi peut-être en ayant gagné ce concours, c'est de pouvoir relayer cette information à toutes les autres personnes. Non seulement le relais des matières qui ont été apprises autant que nous le pourrons, mais aussi le relais du programme tel que organisé par iPeace. Et c'est ainsi que, dans notre université par exemple, un club déjà dans ce sens a déjà été institué durant cette année, un club des droits humains. Pourquoi ne pas mettre aussi un club de droit international humanitaire et qui s'occupera particulièrement des étudiants autour de cette thématique qui est très importante, mais aussi de pouvoir faire participer les étudiants à de tels ateliers, car comme on dit, dans de types de clubs, l'on peut étudier de la théorie, mais dans ce type de programme, on apprend beaucoup plus par la pratique.
Je me nomme Safika Doukourozi, je suis étudiante à l'université de Goma en première année de master. Je suis ici à Kigali avec mon coéquipier qui se nomme Chipamba Ntikala Josué. Il est aussi étudiant à l'université de Goma en deuxième année de master droit public interne. Nous sommes accompagnés de notre coach qui se nomme Franck Choukuru. Il est assistant à la faculté de droit de l'université de Goma. Je suis heureuse et reconnaissante. Je ne m'attendais pas à revenir avec le prix de la meilleure plaideuse. D'ailleurs, je pensais qu'on ne donnait que le prix du meilleur plaideur et je pensais que c'était tous les sexes confondus. Je l'ai appris sur place et j'étais très contente. Alors, remporter le prix de la deuxième place, c'est aussi une très grande expérience parce qu'avec mon coéquipier, nous avons beaucoup appris de cette édition. Et nous pensons pouvoir aider ceux qui viennent après nous, de l'université ou d'ailleurs, à pouvoir prendre à cœur ce défi qui est nôtre, ce défi de pouvoir faire respecter le droit international humanitaire, que ce soit en temps de paix, comme en temps de guerre surtout, et aussi de respecter le droit de l'environnement et toutes ces notions qu'on nous a apprises ici tout au long des formations. Sincèrement, je n'ai pas eu le cours de droit international humanitaire. J'ai eu par contre le cours de droit international public. C'est sûrement le seul cours à caractère international que j'ai eu. Et le droit international des investissements aussi. Mais pour le reste, vu que je sais qu'il y a d'autres étudiants qui sont sûrement dans la même situation que moi et qui s'intéressent au droit international humanitaire mais n'ont pas eu à choisir cette option-là, je pense qu'il serait important de pouvoir organiser plus fréquemment des séminaires en droit international humanitaire, en droit international de droits de l'homme et des séminaires qui seront ouverts à tout le monde pour essayer de faire comprendre aux gens ce qu'est le droit international humanitaire. Une fois, dans les séances des formations qu'on nous donnait, l'un des experts avait dit qu'il conseillait aux gens de pouvoir être des conseillers juridiques des groupes armés. Je pense que je soutiens son avis. Parce que si les rebelles prenaient conscience de ce qu'est le droit international humanitaire, je crois qu'ils agiraient un peu mieux avec la vie humaine et tout ce qui pourrait nuire à l'humanité.
My name is Mukisa Joshua William and I'm from Makerere University in Uganda. For this round of the Great Lakes Moot Court competition, my partner was Mirungi Prima Elizabeth. Well, I expected this to be mainly a moot competition, but when I did arrive, I noticed that besides it being a moot competition, there was an opportunity to learn. We had conferences, trainings, we had interactions, the opportunity to network with people from diverse backgrounds, and this was a cherry on top, because just the order of the competition alone was enough for you to acquire intellect, knowledge, an understanding of this tricky subject, but then with the opportunity to interact with these experts who were there, free access between the students and professors, persons with PhDs, authors, indescribable would be the best word. But also, I think that it inspires students, the young generation. It gives them an opportunity, a space where they can interact with their mentors, people that they would otherwise only meet in books. And so I find that the expectation of it just being a competition has been far surpassed, with this being an opportunity to make new friends, interact with your inspiration, mentors, and also discover new path in life. Absolutely. The knowledge acquired here can be utilized, to arbitrate some of these armed conflicts taking place around the African continent, in the Great Lakes region, how to champion dialogue, interact with people, promote methods of transitional justice, but also bring some of the top criminals to responsibility. And I find that it is a practical activity or engagement that we had here. Not only am I having the opportunity to do what a lawyer would only have the chance at the highest level of a national court, that is at the Supreme Court or at the International Criminal Court. Here, I'm doing that, going 20 or 30 years into the future and practicing, exercising my ability to persuade the court, to exercise interpretation on complex matters of law. And I know that the knowledge acquired here will be utilized in my work throughout, the African continent, establishing the legal footprint in my region and the various areas within the Great Lakes territory. And I'm also looking at interacting with fellow youth, students, guiding them, offering them some advice, what path to pursue, and how best they can also become players in dealing with these issues that really affect us a lot on the continent. Definitely. This activity can help people get access to justice because, one, it is equipping the lawyers that are going to represent these people. But two, it is also creating awareness for these judicial mechanisms, because many people think that when crimes against humanity are committed, or when war crimes are committed, or things like genocide, they're all left to the government to decide what should be done. But then you get to realize that individuals too can participate. The lawyers can press charges through organized groups like NGOs. They can come together and educate people, educate governments, educate leaders about the law of armed conflict. And this then sets a standard through which people know how best they can defend themselves and the obligations that any people engaged in armed conflict would have for civilians and protected persons. So I definitely see this as something that is relevant and is going to enable people get access to justice, because here they do know now that there are crimes like genocide. It is a crime, it is an international crime. So it sheds light on the avenues available for one who is seeking justice.
Je m'appelle Reine Mahoro, je viens de l'Université Lumière de Bujumbura en 3e année baccalauréat dans la faculté de droit. Et je suis ici à Kigali avec mon coéquipier qui s'appelle Steph Darcy Iradukonda et notre coach qui s'appelle Deo Naongiriye. Alors, il est très important de parler du droit international humanitaire dans notre région des Grands Lacs parce que c'est un droit qui va de pair avec les conflits armés qui sont dans certains de nos pays. Alors, pour le cas pratique qu'on a eu à traiter, c'était vraiment un cas complexe parce qu'on devait analyser la situation en profondeur pour pouvoir déterminer les crimes qui étaient en train d'être commis dans ce pays qui était un pays fictif, mais qui pourrait effectivement être un pays de l'Afrique ou bien d'un autre continent. Et avoir à traiter ce cas nous orientait en tant que juristes sur des crimes effectivement du droit international humanitaire, mais aussi les droits humains.
My name is Joseph Isaac Masangula, a student from the University of Dar es Salaam in Tanzania. My team coach is Dr. Petro Protas, and my teammate is Gertrude Makunganya. My expectations when I was chosen to participate in the Great Lakes training in international humanitarian law and human rights were actually going to a platform where I can learn a lot of stuff. Because in the Great Lakes, we have countries which are facing several problems. I can take an example of DR Congo and Burundi, where several problems are occurring every day. So my expectations were, I'm going to a platform where I meet vibrant lawyers of tomorrow who are going to discuss solutions on how can we make efforts to ensure no any problem persists within the Great Lakes region. The message I'm going to go back with in my country, Tanzania, is Africa is one. And we Africans must ensure we unite. We unite in a manner, we need to ensure peace and stability within the Great Lakes region. Not only because Tanzania has an everlasting peace, then I should just sit and relax. No. As a youth, I have the responsibility to ensure I take a full command in order to ensure there is an everlasting peace, not only in my country, but also in the whole region of the Great Lakes.
My name is Jen Namai Wafula and I am from Kenyatta University. It's in Kenya. My teammate is Joel Ngugi Kabena and our coach is Jean Karakanyaboke. The quality of the topics discussed was a good one. There was a good choice on the topics. Indeed, I got to learn that the environment is one of the targets by the belligerents. So it's been a good choice of topics by the organizers, and I wish that they continue doing more of that they continue with that pace so that we get to really understand from the in-depth what this topic of law entails. Let us not leave any topic, no matter how little time we have, let us get to exhaust at least everything that might be a target of the belligerents in war. The knowledge acquired from this training is really going to be beneficial to me, to my peers, and to my community. First, to me, because next semester I'm going to undertake a unit on international humanitarian law. It is an optional unit, but I have opted to do it because I want to get to understand more what law is and the rules that govern war. To my peers, I will get to tell them about iPeace and what iPeace is doing in relation to international humanitarian law. They will get to understand from a different perspective, indeed, that there is an organization that educates persons about this topic of law. And to my community, really, when I get out there and share knowledge that I have acquired from this training, the public out there, law students, non-law students, they will get to understand the laws that govern war, and they will get to know if we are taking part in this armed conflict, there are rules that we must adhere to, and that will make a change to the way people conduct themselves during armed conflict. The experience I had from this training, it actually started from the memorials writing to the advisory panel and to the pleadings session. It's been a learning experience. You get to be corrected by judges, you get to be corrected by the panelists, you get a chance to ask questions from the expert during the conference and also at a personal level. So for me, it has been a learning experience and one I will always be proud of. And as at now, I can say I am living my dream, getting to one of the cities that I have always wanted to be in. So I am thankful to iPeace for this opportunity to experience something I have always wanted to experience. Yeah.
Je me nomme Anchiza Migani Ryan. Je viens de l'Université catholique de Bukavu. Je constituais une équipe avec mademoiselle Kaambuta Sidebora. Oui, notre université, notre équipe a dû remporter le prix de la meilleure équipe dans ce concours. Mais en soi, il ne s'agit pas simplement d'une victoire qui est personnelle à l'équipe, mais une victoire qui appartient à tous. En réalité, le programme à lui seul porte déjà une formation et le concours n'a consisté que dans l'application de ce qui a été appris. Or, tous nous avions appris, certaines circonstances se sont déroulées, mais en réalité, dans ce type de compétition, dans ce type de programme, dans ce type de formation, soit on est gagnant, soit on est gagnant. Certainement, notre tâche à nous, en ayant participé à ce programme, notre tâche à nous, en ayant apprécié le programme, bien sûr aussi peut-être en ayant gagné ce concours, c'est de pouvoir relayer cette information à toutes les autres personnes. Non seulement le relais des matières qui ont été apprises autant que nous le pourrons, mais aussi le relais du programme tel que organisé par iPeace. Et c'est ainsi que, dans notre université par exemple, un club déjà dans ce sens a déjà été institué durant cette année, un club des droits humains. Pourquoi ne pas mettre aussi un club de droit international humanitaire et qui s'occupera particulièrement non seulement de la formation des étudiants autour de cette thématique qui est très importante, mais aussi de pouvoir faire participer les étudiants à de tels ateliers, car comme on dit, dans de types de clubs, l'on peut étudier de la théorie, mais dans ce type de programme, on apprend beaucoup plus par la pratique.
Je me nomme Safika Doukourozi, je suis étudiante à l'université de Goma en première année de master. Je suis ici à Kigali avec mon coéquipier qui se nomme Chipamba Ntikala Josué. Il est aussi étudiant à l'université de Goma en deuxième année de master droit public interne. Nous sommes accompagnés de notre coach qui se nomme Franck Choukuru. Il est assistant à la faculté de droit de l'université de Goma. Je suis heureuse et reconnaissante. Je ne m'attendais pas à revenir avec le prix de la meilleure plaideuse. D'ailleurs, je pensais qu'on ne donnait que le prix du meilleur plaideur et je pensais que c'était tous les sexes confondus. Je l'ai appris sur place et j'étais très contente. Alors, remporter le prix de la deuxième place, c'est aussi une très grande expérience parce qu'avec mon coéquipier, nous avons beaucoup appris de cette édition. Et nous pensons pouvoir aider ceux qui viennent après nous, de l'université ou d'ailleurs, à pouvoir prendre à cœur ce défi qui est nôtre, ce défi de pouvoir faire respecter le droit international humanitaire, que ce soit en temps de paix comme en temps de guerre surtout, et aussi de respecter le droit de l'environnement et toutes ces notions qu'on nous a apprises ici tout au long des formations. Sincèrement, je n'ai pas eu le cours de droit international humanitaire. J'ai eu par contre le cours de droit international public. C'est sûrement le seul cours à caractère international que j'ai eu. Et le droit international des investissements aussi. Mais pour le reste, vu que je sais qu'il y a d'autres étudiants qui sont sûrement dans la même situation que moi et qui s'intéressent au droit international humanitaire mais n'ont pas eu à choisir cette option-là, je pense qu'il serait important de pouvoir organiser plus fréquemment des séminaires en droit international humanitaire, en droit international de droits de l'homme, et des séminaires qui seront ouverts à tout le monde pour essayer de faire comprendre aux gens ce qu'est le droit international humanitaire. Une fois, dans les séances des formations qu'on nous donnait, l'un des experts avait dit qu'il conseillait aux gens de pouvoir être des conseillers juridiques des groupes armés. Je pense que je soutiens son avis. Parce que si les rebelles prenaient conscience de ce qu'est le droit international humanitaire, je crois qu'ils agiraient un peu mieux avec la vie humaine et tout ce qui pourrait nuire à l'humanité.
My name is Mukisa Joshua William and I'm from Makerere University in Uganda. For this round of the Great Lakes Moot Court competition, my partner was Mirungi Prima Elizabeth. Well, I expected this to be mainly a moot competition, but when I did arrive, I noticed that besides it being a moot competition, there was an opportunity to learn. We had conferences, trainings, we had interactions, the opportunity to network with people from diverse backgrounds, and this was a cherry on top. Because just the order of the competition alone was enough for you to acquire intellect, knowledge, an understanding of this tricky subject, but then with the opportunity to interact with these experts who were there, free access between the students and professors, persons with PhDs, authors, indescribable would be the best word. But also, I think that it inspires students, the young generation. It gives them an opportunity, a space where they can interact with their mentors. The African continent, in the Great Lakes region, how to champion dialogue, interact with people, promote methods of transitional justice, but also bring some of the top criminals to responsibility. And I find that it is a practical activity or engagement that we had here. Not only am I having the opportunity to do what a lawyer would only have the chance at the highest level of a national court, that is at the Supreme Court or at the International Criminal Court. Here, I'm doing that, going 20 or 30 years into the future and practicing, exercising my ability to persuade the court, to exercise interpretation on complex matters of law. And I know that the knowledge acquired here will be utilized in my work throughout the African continent, establishing the legal footprint in my region and the various areas within the Great Lakes territory. And I'm also looking at interacting with fellow youth students, guiding them, offering them some advice, what path to pursue, and how best they can also become players in dealing with these issues that really affect us a lot on the continent. Definitely, this activity can help people get access to justice because, one, it is equipping the lawyers that are going to represent these people. But two, it is also creating awareness for these judicial mechanisms, because many people think that when crimes against humanity are committed or when war crimes are committed or things like genocide, they're all left to the government to decide what should be done. But then you get to realize that individuals too can participate. The lawyers can press charges through organized groups like NGOs. They can come together and educate people, educate governments, educate leaders about the law of armed conflict. And this then sets a standard through which people know how best they can defend themselves and the obligations that any people engaged in armed conflict would have for civilians and protected persons. So I definitely see this as something that is relevant and is going to enable people get access to justice, because here they do know now that there are crimes like genocide. It is a crime, it is an international crime, so it sheds light on the avenues available for one who is seeking justice.
Je m'appelle Reine Mahoro, je viens de l'Université Lumière de Bujumbura en 3e année baccalauréat dans la faculté de droit. Et je suis ici à Kigali avec mon coéquipier qui s'appelle Steph Darcy Iradukonda et notre coach qui s'appelle Deo Naonghiriye. Alors, il est très important de parler du droit international humanitaire dans notre région des Grands Lacs parce que c'est un droit qui va de pair avec les conflits armés qui sont dans certains de nos pays. Alors, pour le cas pratique qu'on a eu à traiter, c'était vraiment un cas complexe parce qu'on devait analyser la situation en profondeur pour pouvoir déterminer les crimes qui étaient en train d'être commis dans ce pays qui était un pays fictif, mais qui pourrait effectivement être un pays de l'Afrique ou bien d'un autre continent. Et avoir à traiter ce cas nous orientait en tant que juristes sur des crimes effectivement du droit international humanitaire, mais aussi les droits humains.
My name is Joseph Isaac Masangula, a student from the University of Dar es Salaam in Tanzania. My team coach is Dr. Petro Protas, and my teammate is Gertrude Makunganya. My expectations when I was chosen to participate in the Great Lakes training in international humanitarian law and human rights were actually going to a platform where I can learn a lot of stuff. Because in the Great Lakes, we have countries which are facing several problems. I can take an example of...
Nous allons reprendre notre session et nous allons commencer par
to a platform where I meet vibrant lawyers of tomorrow who are going to discuss solutions on how can we make efforts to ensure no any problem persists within the Great Lakes region.
Alors, sans plus tarder, comme on a commencé par les anglophones, je vais inviter ici le président de la composition pour nous annoncer l'heureux gagnant de cette 10e édition du concours de plaidoirie dans le cadre du programme régional de formation en droit international humanitaire et droits de l'homme. Monsieur le Président, bienvenue.
Merci beaucoup pour... thank you very much. Thank you very much for this opportunity to speak. I have been tasked with the very difficult task of relaying to us the outcome of a very rigorous process. One, we appreciate the teams that came before us, and we agree that you put in the time. And on that occasion, let us appreciate the teams by a round of applause, please. It is an experience to learn,
And that's why I want to ask that whenever you are, and for many other moods you will come to, judges, when they interrupt, they are trying to help you develop a point or direct you. So I want to ask that you listen and don't fear to answer questions. And where you are not too sure, also be like at what moment you can leave it to the guidance of the court. And that happened. And I know I can say much, but it has been a long time. On the case of prosecutor versus drugs, Homer, we at the courts at Velnora choose to agree with the charges that have been preferred against drugs, and we confirm them. Thank you very much, and for that reason, in other words, what we have said is we have confirmed that the team Ellington have won the competition. Let us appreciate Ellington, please. And let us appreciate Ellington. Let us see you. That's enough. Yes. And with that verve as well, I want to ask that we have Eckington to stand up, and we appreciate them. Where is Eckington? Let's appreciate Eckington for an amazing job. I think you can also come. Please come. Let's appreciate them as they come. I am done. So okay. They will direct us now. I think I've done my part, yes? Okay. Very well. Okay. Oh.
Many thanks to the presiding judge for announcing the results. And congratulations to both teams. You may take your seats. We'll proceed with the other events later. So now is the time to invite the presiding judge for the Francophone to also announce the results.
Alors, comme vous le savez, la Cour d'assises de l'État fédéral de Velmora s'est donc réunie ce matin, après s'être déclarée compétente et avoir déclaré la requête recevable pour entendre les observations orales de toutes les parties dans l'affaire des crimes graves commis en République populaire du Tirvania. Après avoir écouté attentivement les observations des parties qui ont été enrichies par leurs réponses précises aux nombreuses questions de la Cour, un débat riche et nourri a eu lieu pendant les délibérations, dont le secret ne sera en aucun cas trahi par aucun juge. Sachez néanmoins qu'il a été très difficile de départager les deux équipes, car les 4 plaideuses et plaideurs ont été excellents. On peut d'ailleurs les applaudir de nouveau. Bravo à vous. Nous avons notamment souligné en délibération la très grande compétence des oratrices et des orateurs en droit international et relevé des stratégies argumentatives pertinentes, percutantes et convaincantes. Nous avons apprécié l'habileté des réponses et parfois des non-réponses des plaideurs et espérons avant tout qu'ils ont passé un excellent moment. Ce n'est pas tous les jours qu'on plaide en finale d'un concours de plaidoirie en droit international. Et nous avons noté que vous avez donné le maximum de ce que vous pouviez pour l'emporter. Toutefois, la Cour a bien dû trancher et accorder une légère préférence à l'une des deux équipes en présence. Elle l'a fait à l'unanimité, même si, pour être parfaitement honnête et rendre justice à la diversité de nos avis pendant les délibérations, nous ne sommes pas totalement à l'abri de la survenance d'une opinion partiellement dissidente, mais seulement partiellement dissidente, car il y a unanimité quant au verdict final. Aussi, dans l'affaire des crimes graves commis en République populaire de Tirvania, la Cour, statuant à l'unanimité, acquitte Drax Elmore de toutes les charges retenues contre lui dans la présente affaire. C'est donc l'équipe de Zach Star qui l'emporte. Vous pouvez venir. Vous pouvez venir ici. Beaucoup d'émotions aujourd'hui. Bravo à l'équipe de Zach Star. Et bien sûr, un très très grand bravo à l'équipe finaliste, l'équipe de Zukon.
Félicitations. You may take your seats. Now we are going to start our awarding ceremony. Can we have your attention? Now that we know the winners of the moot court competition, because we are all the winners of the program, so we are going to start our awarding ceremony, and I am going to ask the presiding judge for the Anglophone to please step forward. The presiding judge will be awarding the winners for the Anglophone track. Can we have Team Ellingwood on the stage? Team Ellingwood is Strathmore University.
Look at her.
As they are getting down from the stage, let me invite the President and CEO of iPeace, Dr. Elvis, who is going to award the finalists. Team Eckington. Team Eckington is Jomo Kenyatta, University of Agriculture and Technology. Allow me to welcome Professor Traore, who is going to award the best memorials. And I believe you have seen from the marks that we shared. I believe by now you should be knowing the best memorials. It's Team Ellingwood. Strathmore University.
Again, you have a lot of work.
Now, at least that you knew. What you don't know is the best overall speaker for the Anglophone side. And I'm going to request Dr. Irene Nyakagere to step forward. The best oralist, best overall oralist for the Anglophone is Allen Ndulu. I have a hard task of now awarding the best female oralists of the Anglophone track. And for that, I'm going to request Anderson Emily to please step forward. I think you don't know this one. The best female oralist for the Anglophone track is Allen Ndulu.
Alors après le circuit anglophone, c'est au tour du circuit francophone de procéder à la remise de prix. Alors, le prix du gagnant de cette 10e édition, je vais demander à Monsieur le Président de la composition de monter au podium pour la remise. Et nous allons inviter l'Université de Kinshasa à se présenter pour recevoir son prix. Yes, okay. Alors, nous allons inviter le professeur Ezekiel Lamani à se présenter au podium pour remettre le prix à l'Université de Lubumbashi qui arrive deuxième à cette 10e édition de ce concours de plaidoirie. Alors, pour le prix du meilleure mémoire francophone, je vais inviter le professeur Trésor Maéché à se présenter au podium pour la remise. Ah, ok. Je viens d'apprendre que le prof Maéché est en réunion. Alors, comme j'ai devant moi le professeur Benjamin Traoré, je vais lui demander de faire la même chose comme il l'a fait pour les anglophones. Alors, pour le meilleur mémoire, est-ce que je dois annoncer? Parce que je pense que vous avez tous les résultats et que vous savez que c'est l'équipe Zucon. Donc, l'Université de Lubumbashi qui reçoit le prix du meilleur mémoire. Alors, après le prix du meilleur mémoire, nous avons le prix du meilleur plaideur francophone. Et pour ce prix, oui. Alors pour ce prix, je vais inviter Catherine Maya se présenter au podium pour la remise. Alors, le meilleur plaideur francophone. J'ai entendu un nom quelque part. Le meilleur plaideur francophone est Élisée Dimundu. Au moins, nous sommes rassurés que ça ne sera pas la même personne, comme chez les anglophones. Alors, pour le prix de la meilleure plaideuse francophone, je vais inviter le professeur Aurélie Tardieu pour la remise. Et je voudrais qu'on lui donne aussi le micro parce que nous avons prévu qu'elle dise quelque chose au sujet... Alors, parmi les prix que nous avons donnés aux différents vainqueurs, vous avez vu qu'il y a des livres qui ne rentrent pas dans le cadre de cette activité, c'est de la littérature. Il y a des romans en français et en anglais qui ont été offerts aux participants dans le cadre de prix. Ces cadeaux viennent directement d'Aurélie Tardieu et il existe une raison. Et je voudrais que, avant, parce que c'est déjà inclus dans le prix qu'on donne, ça ne sera pas donné spécialement. Alors je voudrais qu'elle explique le pourquoi des romans dans le cadre d'une telle activité.
Alors, cette semaine a commencé par une soirée interculturelle dans laquelle vous avez partagé des moments sur des musiques des différents pays de l'Afrique des Grands Lacs. Et je trouve que les arts, c'est quelque chose d'important justement pour l'ouverture sur le monde. Et il y a un principe que j'ai qui est il n'y a pas que le droit dans la vie. C'est-à-dire que l'échange, il existe au-delà de ce concours. Et c'est la raison pour laquelle j'ai choisi de prendre des romans et des recueils de nouvelles d'auteurs de la région des Grands Lacs pour que vous découvriez ces différents auteurs. Donc il y a quelques ouvrages en anglais, davantage d'ouvrages en français, puisque j'en ai trouvé davantage en France. Et puis, il y a aussi quelques petits livres de guides de conversation en langue française pour des anglophones. Promis, l'an prochain, j'en apporte aussi à mes collègues anglophones pour qu'ils apprennent aussi quelques mots de français pour certains. Et il y a autre chose qui sera remis. Alors malheureusement, je n'en ai pas beaucoup. J'espère à l'avenir pouvoir en avoir davantage. Ce sont des sacs. Alors ces sacs, ils viennent d'une association étudiante, d'étudiants à moi à Paris, qui sont des étudiants d'origine africaine ou afro-descendante. Et ils ont créé une association cette année qui s'appelle Roots. Et cette association a une devise, casser les murs pour construire des ponts. Et j'ai trouvé que c'était la même philosophie que le programme d'iPeace, le programme donc de formation de la région des Grands Lacs. Et je leur ai demandé quelques sacs pour justement certains étudiants ou certaines étudiantes pour partager justement cet objectif.
Merci beaucoup à Aurélie pour l'idée qui est très géniale. Alors, maintenant, je vais annoncer la meilleure plaideuse francophone. La meilleure plaideuse francophone de cette 10e édition est Merveille Mouepou. Alors, spécialement pour les francophones, nous avons le prix du jury. Et pour la remise de ce prix, je vais inviter encore une fois Catherine Maya et demander qu'on prépare le micro parce qu'après la remise du prix, elle va dire quelque chose. Alors, oui, quelque chose à propos du prix. Le prix du jury francophone va à Rachel Tsanga.
Alors on a, au moment des délibérations, et malgré toutes les difficultés qu'on a eues pour départager des personnes qui étaient extrêmement brillantes lors de leur plaidoirie, eu quand même une inclinaison à reconnaître le mérite de vos arguments, qui étaient vraiment très percutants. Donc bravo à vous, c'était très 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 beau.
Yes.
This is English also.
Yes. Alors, après ce prix, nous avons un autre prix spécial, le prix d'intégration. Aurélie en a parlé. Nous avons prévu 2 prix, un pour un coach et un autre pour un étudiant. Alors je vais commencer par le coach et le prix d'intégration va au coach Léonard. Alors, pour la remise de ce prix, nous invitons Nelson à se présenter au podium pour remettre le prix au coach Léonard.
And for the same award, but for the student who demonstrated great networking skills and integration is Karangwa Semnaga. And to award Mr. Karangwa, allow me to call on Evaristus Ngoran. This year we have a special award that is very interesting. It's interesting because in the 30 universities that we had, only one university was able to achieve this. And this is having an all-female team, a coach and the students. Please allow me to welcome the Catholic University of Eastern Africa. And to award them, it's my pleasure to invite Leia Mehali. Do you have the coach? Okay, I think she's outside. Okay.
Un autre prix dans le même sens, c'est pour les équipes qui ont été majoritairement composées de femmes. Donc, sur les 3 participants, nous avons eu 2 femmes. Alors, ces équipes sont au nombre de 5. Et pour remettre ce prix à ces 5 universités, je vais inviter Maître John Kazembe à monter au podium pour la remise. Il y a la première université, c'est l'université protestante de Lubumbashi. L'université catholique La Sapientia. L'université Lumière de Bujumbura. University of Dar es Salaam. And the King Caesar University. Hosting. First draft for the hosting. Hosting us, yes. 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 They organized. Yes. No. Quite a friend. Ask him directly. Yes. Alors, nous avons prévu un autre prix spécial pour un étudiant ou une étudiante, parce que comme le docteur Elvis l'avait expliqué le premier jour, un des objectifs de ces programmes, c'est aussi organiser cette connexion entre les étudiants et les experts, donc le réseautage. C'est comme ça que cette année, nous avons prévu un prix réseautage pour les francophones et pour les anglophones. Alors, le prix réseautage pour les francophones va à M. Cyprien Momba. Yes. Alors, pour la remise de ce prix, nous allons inviter M. Xavier Maki, alors, voilà, on vient de me faire remarquer qu'à la fin, nous avons décidé qu'on devait remettre à un seul étudiant. Que pour ce prix, on ne devrait pas faire la distinction entre francophones et anglophones. Parce que, effectivement, anglophones et francophones doivent aussi créer des réseaux entre eux. Lui, nous avons reçu des témoignages de beaucoup de gens que nous avons consultés, qu'il rentre chez lui en RDC avec presque tous les numéros de téléphone. Et ça, c'est étudiant et expert.
Yeah, now we also have a special recognition, and this is for Strathmore University for the hosting that I've done for us, which has been wonderful. And I would like to welcome Malcolm Kibati on behalf of the organizing team. And to award this, I'm going to request Mr. Bernard Nzama, the Programs Director of iPeace, to award this special recognition.
Alors, pour les derniers prix que vous voyez là, nous allons faire un exercice simple parce que pour nous, c'est important de savoir que les supports de communication que nous mettons à la disposition de participants sont exploités. Alors, pour cette année, nous avons prévu d'organiser un prix pour les universités qui sont arrivées en 3e position. Mais pour ça, moi, je ne vais pas les citer parce que les résultats ont été communiqués. Je vais appeler l'université qui reconnaît avoir été 3e dans le circuit francophone à se présenter pour recevoir le prix. Ah, au moins, notre équipe de communication a la preuve que les supports de communication sont utilisés. Alors, pour la remise de ce prix, ah, ok. Alors, pour la remise de ce prix, je vais inviter Catherine à se présenter au podium. Et Robat va présenter, sans citer le nom, l'université anglophone qui est arrivée en 3e position. Robat. Oui, alors Catherine peut remettre le prix à l'équipe et comme ça on... Ok. Alors pour aller plus vite, l'équipe anglophone aussi, qui sait qu'elle est arrivée 3e, peut se présenter au podium pour recevoir le prix.
Okay. And I think you already know. Team Ecrins. And to award this team, I'm calling on Musonera Innocent. Before we reach the conclusion of our ceremony, there is an important task that we have to do. And I think it's one of the most important activities that we have today, to recognize the participants. And allow me to call on Dr. Elvis Mbembe and Dr. Ezekiel to step forward. We are going to present certificates to the participants. And I'll be calling out the names. We are going to do this exercise quickly, so I'll be calling out the names. You just pick your certificate, you take a picture, then you proceed. The certificates are in no way in order of ranking. So don't mind about if you're last, don't think you're the last participant. Can we have Innocent Dakan Mayomba? And Ahura Precious. As they come, let's also have Jonathan Romole. Rebecca Ndanu Mwenda. Grace Ingabire. Karangwa Semnaga. Can we have Diana, please? Daniel Ola. Lamek Claire. Christine Njeri Nderitu. Kamara Castro, Castor Ingalio, Kazeneza Sierra, Benta Adikinyi, Allen Ndulu, Alex Musimenta, Simon Gasheshe, Harriet Anguzuru, Zubai Kanyereketo, Owen Mayanja, Owen Mayanja, Nkarubo Oprah Blessed, Hilary Ayobazibwe, Shidra Aturinda, Pelon Hogoza, Amos Nietiwe, Mary Ban Isaac, Faith Mpito, Kevin Manzimucho, Chubahiro Manzi, Nyarunda Maslin, Edwin Obonyo, Elkana Bosire, Christine Monyanji. Kingsley Kimat.
On va directement enchaîner avec les francophones. Sagesse Omari. Joël Minani. Blaise Mouko. Bernice Murozawimana. Tracy Chloé Keza. Jenny Elsa Izere. Espérance Biangwa. Christian Mouindo. Élisée Dimundo. Gloria Brigitte Wasingia. Dorcas Kabouiz. Cyprien Mumba. Sarah Zigabe. Gabriela Muzinga. Merveille Mouepou. Saïdi Routiba. Honorine Lissambo. King George Kaluta. Gédéon Kalonji. Jeannette Simba. Joyeuse Zawadi. Marthe Mwenge. Israël Bossamba. Rachel Tsanga. Miope. It's very long. Ah, okay. Not yet. Not yet. There are many. Okay. Miope. Ngenda Kumana. Ah, he's not there. Okay. Aimé Merlin Bia. So all these I call them together. No, together just for a picture in the group.
Can we appreciate Dr. Elvis and Dr. Ezekiel? So I can see that people already, according to the program, have already scheduled some appointments, and the places we saw yesterday, you can't wait to visit them. But before we end the day, before I announce the last program of the day, I just want to make a few quick announcements. The first is, as I mentioned in the morning, according to your requests, your lunch allowances are being given, and due to the logistical arrangements, as we are now going to head back to the hotels, the allowance for people who have not received, because I know the majority have received the allowances, then we're going to get it at the reception of our respective hotels. Our staff are there to handle that matter. So as we get from the bus to the hotels, that will be sorted. And although we are going to visit the places we saw yesterday, please don't forget don't forget to remember. So don't forget that we have an interesting gala dinner in the evening. I know on Monday for the cultural dinner, people were rushing because they had sessions in the morning. But today, we want to have at least everyone at ease. And we expect more dances and enjoyment. So the dressing code is tenue de ville. If you can't understand French, I will not explain. Look for translation. But you have to be dressed in tenue de ville. So the buses will be picking us from the hotels at 6, from 5:30 to 6, and the gala dinner is starting at 6:30. So let's all meet at Weston in the evening. For now, please allow me to invite the President and CEO of iPeace, Dr. Elvis Mbembe, to give us the closing remarks for this program.
Good afternoon, everyone. I know that we have had a very long and emotional day, so I'm not going to make a very long speech. I would like, first of all, to start by congratulating everyone for your participation in this 10th edition of the Great Lakes Regional Training Program in International Humanitarian Law and Human Rights. But more specifically, I would like to congratulate the winners of this edition. For Strathmore, I tried to go back into our books. I've been told, but we'll again check to confirm, that this is the first time that we have a back-to-back, like the same university winning 2 times successively. So big congratulations. Before I proceed, I suspect there could be a question about the way we do the calculation to reward the best pleader. Because for some teams, it coincided that you have the best pleader among the finalists. But what I would like to precise here is that to be the best pleader, we don't consider the final. We consider the marks that you accumulated in both rounds when you pleaded as prosecutor and defense team. And we consider the marks awarded by each judge, then we make the calculation, and that's how we end up having the best pleader. So for some, it coincides that it is a team that is in the final, but others, as you could see, it could be a different person. So with this, ladies and gentlemen, in your titles and different capacities, allow me to thank you for your participation. But I would like, first of all, and more importantly, to thank our donor, that's the Kingdom of the Netherlands, because they are the one who allowed us to come from different corners and to be in this room today. Please give a round of applause to our donor. Thank you very much. I would like also to thank our partners in this Access to Justice project, I know that you were all there during the opening, and there was a presentation about this project. The project is implemented by 3 organizations, and the lead is International Alert, and we also have another partner, Pole Institute, and iPeace is the 3rd. And this activity falls within the realm of activities to be implemented by iPeace. So I would like to thank International Alert and Pole Institute for the partnership that we are having in implementing this project. I would also like to thank Strathmore University for this very strong and meaningful support. From day one, we knew that we were in good hands, but as they come in, days go out, we only confirm when we look at the infrastructure and every kind of support that we received. We are very much thankful for this support. Our experts, you have done a great job. Also, thank you very much, and we hope to see you again. To all the participating universities, I would like to say a big thank you through the coaches who are here. We don't take your participation for granted. We know that making it to these final rounds means a lot. We start from the preliminary memorials, then we go, and reaching this point from the 62 universities that participated, I think you have been very instrumental in making sure that your universities participate. So thank you very much. I would like to come back to Strathmore University, but in a particular note. I would like to thank the team that has already been recognized, the team that was led by Malcolm. Is Malcolm in the room? He's surely trying to make something happen before we leave this place. So we say a very, very, very big thank you for the team, for the support. The feedback I've received from my team is that you were really blended. You worked as one team, and we appreciate very much what has been achieved here with your support. I have the team from iPeace. We have team from iPeace DRC and our team from iPeace Rwanda. I know that you have spent sleepless nights or short nights with a lot of pressure to make this day happen. So we are very grateful for the good work that you have done, and we believe this is what we want to see, and we believe that you'll do even better in other editions to come. Thank you very much. You have noticed that we have received a lot of books, these red books, and we still have some pending there. We'll decide to whom we'll give these books. We are very much grateful for the support they gave us despite the short notice. We received a very big number of books that have been now given, and here we are just participating in the popularization of IHL. We believe that the books that you have received, you'll take time to read, to double check the provisions that you have been citing when you are writing your memorials and even when pleading. At the same time, I also want to extend my thanks to RCRC regional delegation based here in Nairobi. They were also very much supportive of the idea. You saw the head of delegation, where during the opening, you also saw Sahar, who did the presentation during our international conference. We don't take this kind of partnership for granted. We appreciate a lot. Last but not least, I would like to thank the interpreters. If we are in this room, people who can't speak French, who can't speak English, and we are able to understand each other, it's because we have people who are helping us to break the barriers. They are not seen. We take their voices like something that is granted. But I was told that when you consider the most stressful work in the world, it is simultaneous interpretation. Because the person not only has to say what you have said, but must start guessing what you are going to say. So we should not take this for granted, and let's give them a round of applause. So before the gala dinner, I'm very happy and confident to say that we can't wait to have the next edition. We are soon to decide how it will be done, but you receive emails. We encourage you not only to apply, but also to spread the news so that many other universities can apply. But more importantly, you have taken the lessons. Of course, you are not participating again because the principle here is you only participate once as a student. So make sure that those who will come after you can do better. Take the lessons that you learned from here, tell them what they have to do so that they can expect a very happy ending. So with this, ladies and gentlemen, I'm very happy to declare closed the 10th edition of the Great Lakes Regional Training Program in International Humanitarian Law and Human Rights. Thank you.
Before we leave, just one final announcement. There are people who have registered to visit the museum tomorrow. So the program is that you will be picked at the hotel at 8:30. So let's be ready at 8:30. And we just have a slight change in the program. We have T-shirts that we need to issue out to the participants. And we think it's better if we just sort the logistical issues that we discussed right outside here, then we can leave. For the experts, the bus is waiting. You're ready. So we can have the coaches and students. We sort the logistical issues, then we can go one way. Thank you.